Hello and welcome. This is Grant Hughes of Grant Hughes Investigates on YouTube. This channel evaluates all aspects of true crime. As you are aware, videos and live streams in this genre often discuss elements of crime that may be disturbing to some viewers. If necessary, take the precautions needed to avoid these feelings. Factual information related to cases is the key to fostering rational true crime discussions. Fortunately, you will find that here. Please hit the like button only once, share the video, and subscribe if you like my content. Thank you very much for watching.
We're all Richard Allen!
You pieces of shit got to the jury, didn't you?
You pieces of crap got to the jury, didn't you? Oh, God. Oh. Well, I was going to be doing something else tonight, but the judge has come back with his rulings on all of the different motions that the defense put up in the Idaho 4 case. But before we go to that, I have this murder for hire case in California. Yeah, it's pretty absolutely crazy. It's got surveillance footage, and this lady gets killed by somebody hired by. So what it's only going to be, we'll spend probably, I don't know, 30 minutes on it, and then we'll switch over to Kohberger. But I already had all this planned, so you know, we're going to take a look at that. Pretty crazy. Let's see. Yeah, so first I'll play this surveillance footage. I mean, it's absolutely terrifying. I mean, you can just tell how scary it would be. There's even a guy that comes out and tries to help, and he gets shot at, so he runs away, obviously. I mean, he didn't realize that was happening.
Chewbacca?
Hey, look at that. It's Timothy Cecil's birthday.
Went out to eat at Outback Steakhouse.
Well, awesome. Well, thank you for sending me $10 on your birthday. Anyways, I hope you like the... did you get a good steak? You like medium rare? That's what I always eat. Well, it's like medium rare or more rare. I don't want something the other direction. I wouldn't mind if it was something that was still moving. You know, I like almost completely... like rare is good. Hey, Castle, what kind of garbage are you doing here, man? Go put that garbage somewhere else, okay? Let's see. Thanks for getting rid of that, mods. Appreciate it. Oh yeah, check it out. Check it out. You want to hear like an actual true crime using my own skill to help my, you know, like using surveillance footage to figure out my own. I mean, it's pretty interesting, you guys. Today, so look at that. We had to help my dad move some of his, they moved into like a retirement home facility. You know, so they've been moving stuff out of their house, and there's a bunch of garbage left, so I had to clear out the back of my Subaru to make, you know, so I could move the seats down and make it nice. And while I was doing that, I had my keys in my hand, and I had the, I didn't have shorts on that had pockets. They were just sort of like these, you know, shorts I sleep in, really. And so I just had the keys in my hand, and then I was moving stuff back and forth. And then I couldn't find the keys in the house, and I went back out to the car, and the keys aren't in the back of the car or anything. And I looked everywhere, and by 30 minutes later, just absolutely like, God, this is shit. Did somebody walk by and like take the keys? Or, you know, you start panicking because there's no way you should be able to lose those based on what I was doing. You guys here? So anyways, I couldn't find the key, and it was just a nightmare. I was just sitting there going, you know, where the hell is it? So then we decided to look at our Ring doorbell footage. And then there was some footage, but it was kind of didn't show as much as I wanted. And then the front door camera, it didn't pick up any of the trips back and forth except the last one. And in that footage, just as I'm about to get to the door, I see my keys in my hand. Okay, so we looked everywhere for this, but I see the keys in my hand and it's wiggling, and then I noticed, well, what am I carrying there? That doesn't look like... And then I forgot what I was doing, and then my wife said, that looks like bottles. And I went, oh God, and then we ran over to the garbage can and moved the bottle, there was like it wasn't a garbage can, it was like a bin to put bottles in, and I moved it aside, and there's my keys sitting right there. Oh my God. I don't think I ever would have found it. I think they would have been lost forever. But that 2-second video on Ring doorbell allowed me to go find the damn keys. I mean, it was amazing. I was like, hey, the shit that I do came home to roost. Hey, thanks, Wonder Woman.
Birthday contribution, birthday cake,
I mean, that was a nightmare. I mean, it was so crazy, though, because it's like, okay, now it proves that it made it back into the house. And then we went over to the garbage can, and there it is at the top. I think it was underneath the, like, those hand warmer, the little plastic thing that you tear it out of that you can get at Costco. That's what was on top of the garbage. And I moved it aside, and there it was, man. I'd thrown the keys into the garbage can. Just because they were in my hand and I wasn't thinking. Pretty crazy, though. That I don't know why we'd ever checked that garbage can. I don't know if we would have found it. It would have just been one of those mysteries. But there you go. Oh, I hate it. I was like panicking because I don't have any, we have a backup set, but then you're like, well, shit, did somebody else get that? And then you got to change all your locks, and then you got to... Yeah, it was pretty crazy. Couldn't believe it. My actual surveillance footage skills came into work for something on my own. Anyways, let's take a look at this surveillance footage. This is down in, I think it's, San Bernardino, California. And I guess before we, hold on, let me go to a different thing here. I have the address. It's right here. Alright, so let's just put that in. So right here in San Bernardino, and apparently, I can tell by looking, I think it's right here actually. Because I can tell by just in my head that donut place over here was visible. So I think it's literally right there in this parking spot is where this all happens. Okay, so let's just looking at this right here, and then you look at that. Wow, Jesus, really? Is that the same freaking... Do you guys see that that vehicle? That's her vehicle there. Does she work there or something? Oh wait, it just looks so similar, but that's not it. Look at that thing. Jesus, that almost looks like the same one, but you can tell it's not. Alright, but see the donut shop over there in the background, donuts, and so that must mean that it's parked right in that same location. If you look at the, let's see. Well, actually, it might be right at the bottom of the ramp, so a little bit farther over there. Hey, Karen, thanks. Oh, look like a NASCAR pit crew. Alright.
Hi, Gray. You look like you should be on the NASCAR pit crew tonight. Very nice. Winking face.
Well, thanks. People like the red. Remember that? All right. Who was that one person a long time ago? They always liked the red, and then we thought she became somebody else. I can't remember. Anyways, here we go. Watch this. It's nuts. Absolute lunacy here. So there she is right there coming out. Just went into the burger place. And then look at this car over here. So let's go back a little bit and see where that car came from. So look, it was waiting for her. Isn't that nuts? See that car right there? Can you see it over there? This vehicle right there is waiting for her to come out. And then watch this. When they see her come out, so she must have to clear like this area. Now they see her. Okay, start your engine. And here she goes, making her way to the vehicle. And there they come. See this? And then look, this guy gets out, and he's got like a silencer. Really long thing. But what's crazy is like, here you'll see some amazing, just wild footage where he misses her point blank. See, look, he's talking to her, and then, boom. I mean, look at the window. See the window on the passenger side? Watch, it gets blown out right there. Bang. He missed. I mean, that's amazing, right? She gets the hell out of the way. Boom. Misses. And then he had to, only by sheer luck right there, he had to, looks like he had to kind of clear a jam in the gun. And then shoots again and misses. And look at it, goes out the window again. Look at it right there, watch. Boom, out that window, right? Misses again, unbelievably. Then she comes out and is like really doing what, you know, I guess you have to do to get away from somebody like this. So here she is over here. And look at it, she's grabbing onto the gun, trying to get away. Then he's hitting her over the head. He took her purse, and I'm actually thinking the purse was just to prove that they did it. And then look at this guy came out to try to help, you know. So good on that guy, but he didn't realize there was a gun. He was going to come over and fight this guy that was attacking the woman. Watch, from a wide angle shot here. Let me make it like more like that. See, this guy comes out, and he's going to come over and start helping. Good for him, right? But then, boom, man, you got to get the hell out of there. That's a lethal. And look at, he's shooting at her, missing, and she's hiding on the other side of the car, trying to get away. And he runs around, and then she's still running around. And look at, he's missing her all these times. It's amazing. Misses there again, and then this time she tries to run away, and apparently right there he kills her. But he finally hits her on those. The way they described it was they hit her. She went to the ground, and then he went over and shot her multiple times. It's just brutal. So anyways, let me play this. I kind of did a version where I'm just sort of animated it, moving it around. I mean, this is just unreal here. Look at this. Look at this thing. I don't think I've ever seen anything so just kind of brazen, just out in the middle of the day. It's noon, you know, just kind of, and there's people walking around. And missed there. Clears a jam, shoots it again, misses again. And then she's running out, and I mean, wow, it must have a jam again or something. And now he's hitting her, and they thought it was a purse snatching originally in the news, like the police did, because it's kind of what it looks like, right? When you watch, look at, he's missing again, missed again, and I guess apparently he shot 9 times. I mean, how is he missing those ones? That's crazy. And then apparently this one right there, he got her. It's crazy. Anyways, I don't know. It's just, but let's listen to what the press conference said, and then after that we'll move on to the Kohberger hearing results, right? But look, there's a car right there. There's a driver. So there's multiple people. Apparently they've arrested 5 people, and it turns out it's the husband of her that hired all of these people. So now it sort of reminds you a little bit of, you know, Kendra Hatcher and multiple other cases out there, even though that's not absolutely the same. It's just sort of another murder for hire plot. I mean, she was really fighting to survive, you know. And that guy, I mean, he even came out to try to help her, which was really cool, you know. But I think most people, when a gun is introduced, you get the hell out of there, you know. I mean, and that's why it's good if people are armed Because if that guy had actually had a gun, he would have just been able to take that guy out. And that's exactly what they're for, is situations like that. Or self-defense. And apparently she got hit, went to the ground, and he goes over and shoots her. So let's just listen to this. It's only 19 minutes long. But hey guys, if you're out there and you can help support the Grant Hughes Investigates YouTube channel, I would appreciate it. Just doing another night now. It's like every single night we do the shows, and hopefully we can get the support up every single night when we do these shows. Alright, so here we go.
That the efforts of our team, of our investigators, bring some small measure of closure to the family and all those impacted by this. This homicide took place on January 10th, 2025 at the Burger Point restaurant at 444 West Mill Street.
Yeah, so this happened on January 10th, and I don't think any of us have heard of this yet, which is weird, you know.
This brazen attack happened in broad daylight, in full view of patrons and employees who were working at the restaurant. Our investigators immediately assumed the case and worked tirelessly and quickly developed leads that ultimately identified and led to the apprehension of the
Hey, and by the way, thank you to Steph on Buy Me a Coffee.
Suspects who orchestrated this murder. I want to publicly commend the team for their outstanding work in this case. However, I want to make it known that this is not an anomaly. Our homicide team has an 80% clearance rate, which is far significantly higher than the national average, meaning that if you commit a murder in the city of San Bernardino, there's an 80% chance that you will be hunted down and you will be brought to justice. It's also critically important to inform our community that this was an isolated incident. I understand full well that when incidents like this occur, it brings a lot of fear and concern for personal safety. But there was never a general threat to the community, as we learned very quickly that these criminals targeted this victim in a murder-for-hire scheme that was stemming from a contentious divorce from one of the suspects, Sergio Reveles. I want to also quickly...
You know what's interesting is I think I found the... let me show you this really quick. Her house. And she didn't live in San Bernardino, but let's see. That's one of the addresses that I found in a different software program that she'd been to, or was associated with her name. But this is her house right here, and you know, it's a pretty nice house. So I don't know what she does for work or anything like that, but very nice house. And apparently her ex-husband, or husband, whatever the hell he is, they're going through a divorce, he lives right here, and very you know, nowhere near that same level. So we don't know what the situation is with that, but that's where he lives. Back to this. Thanks, Mama 457 Rose, Amber Maiden, and Alley Cake.
Thank our partner agencies who assisted us with this investigation: the San Bernardino County Sheriff's Department, the Riverside Sheriff's Department, the California Highway Patrol, the FBI, and the Bakersfield Police Department Violent Criminal Apprehension Team. Now I'm going to invite Detective Dominic Martinez up to discuss some more details of the case.
Morning, everyone. Again, thank you guys for being here. We're going to start off by playing the initial video that we had to start our investigation off. As my chief said, it was at the Burger Point here in San Bernardino in the 400 block of West Mill Street.
My video looks better.
So you'll see up in the left corner there, the television, is the suspect vehicle. This is our victim walking out to her vehicle, the Mercedes SUV. That's our suspect vehicle coming up. The front passenger is going to exit the vehicle, later identified as Geraldo Llamas.
That's the husband right here.
During this time, there's some sort of conversation going on.
Jabba the Hutt.
He's asking for her purse, gets a hold of her purse. You see he does have a firearm in his hand. He does make an attempt to shoot at her. The victim was able to fight back. There's still a struggle over the firearm. You'll see some citizens did attempt to help her out, but who were also shot at. There's a total of 9 rounds shot at the victim, with one expanded casing, which was from the gun jamming when the victim was fighting back. And chasing around the vehicle, firing multiple times at her. At this point, the victim does make an attempt to run inside the business for safety. Unfortunately, she was struck, slowed her down, and the suspect again shot her an additional time with a fatal wound. When officers arrived on scene, they located her in the doorway, unresponsive. She was immediately pronounced deceased by paramedics.
Wow, she made it all the way to the doorway.
There was a citizen who was able to provide as a license plate and description of the vehicle that the suspects had fled in. And then we were also given this video surveillance immediately, which assisted greatly in the investigation. Later on during the investigation, we located...
I mean, it's so brutal watching it because you see how, just think about how fearful you would be, and she just skirted death like 5 times and, was trying to get away, and then she gets hit, and then she's struggling, and then he goes up and shoots her fatally. I mean, he had a lot of time there. It's wild. And unfortunately, not a lot of people are armed in places like California compared to Texas. I think that same guy that was running out in Texas would have had like 4 guns on him or something, and he would have done something to take him out.
Did this SUV, being the suspect SUV, abandoned on the east side of town in the Walmart parking lot.
Yeah, I think they've kept this case pretty quiet. What did they just say? Let me hear that. Hold on.
Later on during the investigation, we located this SUV, being the suspect SUV, abandoned on the east side of town in the Walmart parking lot. Surveillance in the local area was checked. The suspects had then got into a second vehicle, which was located at another business. There we saw that the suspects had changed their clothing and went inside a business for a short amount of time, got in the second vehicle, and fled the area. Within approximately 4 hours, we had both suspects identified. The shooter, Geraldo Llamas, the driver, Arnold Ruales, were ID'd as our suspects. The very next morning, we had our surveillance team with the Inland Regional Apprehension Team, part of the FBI, conduct surveillance on Llamas in Bakersfield, California, and then also conduct surveillance on Mr. Arnaldo Ruales in Los Angeles, California. We've recovered the initial vehicle that they had fled in, the SUV. In that vehicle, there was evidence leading us to additional suspects and evidence with the case. So approximately a week later, Thursday, I believe the 16th of January, we obtained arrest warrants for Llamas and Ruales. Teams with the Bakersfield and FBI teams served warrants at the Bakersfield residence, and then teams with our undercovers.
This guy's the husband right here. He's the one that hired all these people to do it. And by the way, this guy right here, he can hear really well in front of him. Okay, not so much behind, but in front of him, my God, it's like a sonar. Let's see.
Local agencies served warrants at Ruales' residence. So there was always one thing that we had always asked ourselves, like, what's the link between the victim and our 2 suspects? Just always something that was in the back of our minds. So looking at further evidence that was recovered during the initial search warrant of the vehicle and following up on leads on these gentlemen,
right,
we determined that the third suspect, Reynaldo Ruales, was the brother of Arnoldo.
I like big ears, but this guy's ears are pointing straight out, man. I bet you if a gust of wind hit him, his head would snap.
Ruales. I was able to then determine that Mr. Reynaldo had worked for a Juan Perez
Welcome, Ken.
at a local pallet company in the city of San Bernardino. The pellet company that he ran was owned by our victim, Ms. Torres, and her husband, Sergio Reveles. So there's the link that we found between all of our subjects. A search warrant then was authorized for Reynaldo's residence, and a large amount of U.S. currency was located in his house, along with a large amount of U.S. currency at Mr. Arnaldo's residence. Additionally, the suspect Llamas currency was located at his residence and on his person. Also, the clothing and additional evidence related to the investigation was located at each suspect's residence. So we did end up talking to each of the individuals, and then we ended up getting a lead to Mr. Perez and then Mr. Reveles. From there, we served a 7-location search warrant on businesses and residents related to all the individuals involved. There we were assisted by the FBI, CHP, Riverside Sheriff's, San Bernardino County Sheriff's Department. During those search warrants, there was evidence related to the crime recovered, to include large amounts of money, over $200,000 in cash, and numerous firearms. These subjects were later arrested and booked for the murder of Yesenia Torres. So all subjects, all 5 suspects, are currently in custody for her murder.
Next up to speak about the case is going to be San Bernardino County District Attorney Jason Anderson.
Thank you. Good morning. As a result of the investigation that the chief and detective have talked about, when this case was turned over to our office, the initial arrest of the first 3 defendants was on January the 16th. We filed the case on the 21st of January as to the first 3, the shooter and the 2 getaway drivers. And when we filed that case, we filed special circumstances that related to those 3 individuals. That's currently where it stands. As a result of the continued investigation that San Bernardino Police Department engaged in and the other agencies, the 2 additional suspects were arrested on February the 13th. We also filed murder charges against the business partner, Mr. Perez, and the husband, and also alleged 3 special circumstances that relates to all 5 defendants. And so currently what they're each looking at is a count of murder with all the special circumstances that would include lying in wait, financial gain, and the crime committed in the commission of a robbery. And that's currently how we'll proceed. I want to be very, very clear that any time a DA's office talks about these matters, there's only so much that we can go into just to give you the logistics of what we filed, when we filed it, why we filed it. Each of these individuals are innocent until proven guilty. That's the protections that they have in this country, and we're glad for that. The next hearing, as it relates to all 5 of the defendants, will be on March the 14th. We were fortunate that we were able to link up all 5, even though the arrest and the charges happened at separate times. We will proceed on this matter as is currently alleged, with the potential of special circumstances as a result of some of the facts that you've heard here, and obviously the tragedy and travesty of having an individual that was essentially assassinated at one of her favorite eateries in San Bernardino. Is a very, very sad case. So I commend the department here, specifically Chief Goodman, his team, everybody who worked on this case. It was an unbelievably tireless effort because you could sense all along that there had to be more to the story. We believe that we've actually encapsulated the entire story, but their diligent work to go.
Yeah, we're going to get to the Kohberger thing, but this is something I was working on during the day, and then those files were uploaded, and so I'm going to add that into it. But I want to go over this, and I'm also looking for, if anybody out there can find me the new search warrants on the Asha Degree case. There's 3 of them. I have the ones from like in September of last year, so if you find those, don't send them to me. I've already got it. If you can find the 3 new search warrants that just came out, that would be awesome. Tell you what, if you're the first one to send me that, I'll send you the whole notebook package. All right. So send me if you find the new Asha Degree search warrants, and you're the first one, I'll send it to you. But put the address in the email when you send it, just in case you're the winner. All right.
go from January 10th until February the 13th to be able to get 5 defendants in one case.
Thanks, Vicky.
With the evidence that they presented to us that is the result of the charges. I commend their agency and everybody else who was involved in it, and particularly witnesses who came forward very early on and were willing to give statements and try to make identifications, and ultimately that led to the arrest of all 5 of those. So just appreciate your time this morning and allow us to explain who we charge and why we charge it and the theories going forward. Sergeant, all yours.
They do have questions. I boosted up the audio.
All right, at this time, we can field a few questions if anybody has any. Just keep in mind that we will have a press release that will be out later today as well.
Question about, and I know there's a lot you can't talk about, but is there someone can give us a little bit more of the narrative of the murder for hire part of it? It sounds like you said the suspect, Sergio Reveles, was in the middle of a contentious divorce with the victim, but was there evidence that he,
cool, Lisa,
on his cell phone, that he wanted to hire these people to commit this murder? How much money did he pay? Is there?
Do you know we had 275 people? Now there's 225 because we just didn't stay on Kohberger right off the bat. See, that's what I think sucks, is that there's people out there, they're not really into true crime or anything like that. This is an interesting story with a crazy video, but people are just and it's like, come on, you guys, be interested in other things a little bit.
Any more to that narrative you guys can give?
Gotcha.
And that's what makes me nervous on this channel to switch topics to something else, because this is what happens. There was 275, now there's 225, because it just wasn't Kohberger right out of the gate. All right. I'm looking for people who are interested in true crime, like everything, and I don't know how to explain it, but it just sucks that people just take off right in the middle of something because it's not Kohberger yet.
That might be best answered by Detective Dominic Martinez.
Thank you.
So like we said, unfortunately, there's not much information when it comes to the amount of money that we can release. There is an overwhelming amount of evidence for this case to say that it is a murder for hire case. As you saw, there was money located at the residence of each of our suspects, along with firearms located, which is all related to
It
this
sounds like they were paid a ton of money to do the killing.
case. But unfortunately, at this time, we can't give the facts as to when, where, and how much money was released.
Could we say thousands, tens of thousands, at least a general?
Yes.
Tens of thousands or thousands?
You're close to the hundreds.
So hundreds of thousands?
Yes.
Okay.
Wow.
For each amount of
Hundreds of
cash.
thousands.
Yeah, unfortunately, can't disclose that.
Can you guys also elaborate on, so she had no connection to this eatery, correct? It was just a pallet business?
Hey, good for you, Laura.
So,
Not sure what that has to do with what we're talking about.
the victim, Miss Torres, and Mr. Reveles, her husband, they own multiple businesses within our county, LA County, Riverside County. There's assets in the millions that they have, but they have strong ties to the city of San Bernardino.
So could you say that because it was a contentious divorce, were they battling over who was going to take which business, how much money each person was going to get?
So the divorce has been a process for over 2 years. And as you know, when there are multiple millions of dollars involved, there is going to be some going back and forth over assets. I can't say specifically for this case which assets, if any, they were going to fight over or arguing over. But we know that, as we said earlier, that it was definitely a murder for hire case. There is evidence to show that the suspects did stalk our victim for several days and months prior to this murder.
Sounds like the divorce was not finalized, correct?
It was not.
You say the suspect stalked the victim, you're talking about the husband, Mr. Sergio Reveles?
No, I'm talking about Mr. Llamas Reveles, Arnold Reveles and Reynaldo Reveles. On the day of the murder, they were stalking her for several hours.
What are you talking about, my Vespa? A guy came in to try to help when she was being attacked by the person but the person pulled out a gun and aimed it at him, and what are you supposed to do, run right towards the bullets? What kind of a dumb comment is that? Just stupid. You know?
Actually met at a local place, they being Mr. Llamas and Ruales. They met in 2 separate vehicles, one being our vehicle that you guys saw in the video surveillance, and then the other being the getaway vehicle. They met in
I'm going to put that person on. Nobody was a wimp in this case. Okay? Nobody was. The woman fought hard. A guy came out to try to help, and then he got fired upon, too, so he ran. Okay? But he came out to help. He was doing the right thing. So you're going to have to get the hell out of here. All right? Maybe come back in 10 minutes when we're on a different story. You sound like a lunatic.
In an area of the city and went to the victim's residence and watched her for several hours, following her to her business and then following her to the eatery where the murder occurred.
Was that first suspect vehicle one of theirs? Was it a stolen vehicle?
It was one of their vehicles.
Where's the pallet company?
So it's actually in the southern portion of the city, Sergio's Pellets.
The person running around, chasing her around, shooting at her, who was that individual in this group?
That is going to be Mr. Llamas, Geraldo Llamas, who was the front passenger, and then Arnaldo Ruas was the driver of the vehicle. They were the only 2 occupants of the vehicle at the time.
And Arnaldo is Sergio's brother?
Arnaldo is Reynaldo's brother.
And what was the suspect vehicle again, I'm sorry?
Suspect vehicle was the gray. It was a Ford Escape. And then our victim's vehicle was the Mercedes SUV.
I know you said that you guys had discovered the clothing at each person's home. How did you know that that was the clothing that they were wearing at the time? Did you find blood on any of the clothing, or what?
So there was, as you know, there's surveillance cameras everywhere. In this
wouldn't that be
case,
crazy if these are some of
it was
those
fortunate that we were able to find a lot of good surveillance all the way from the victim's residence to her place of employment to where the incident occurred, to where they dropped off vehicles and changed vehicles, and we're able to match up all the clothing they were wearing throughout the incident there and there when they fled.
Was the victim residence also in San Bernardino?
No.
Can you say what city that was?
No, sir.
Just to confirm, Reynaldo Ruelas is the one who worked at the pallet company that was owned by the victim and the husband.
So Ronaldo worked for Juan Perez, who had a pallet company on the property that the victim and her husband owned.
And when you found that out, that was sort of one of these aha moments.
Yeah, like I said, the whole time it was always like, hey, what's the link between all these people? Like we couldn't find that link, and it's always why when you conduct these investigations. And then when that happened, as we were serving search warrants at 2 of the suspects' houses, it was like you say, that awe moment where it's like, all right, we got it, we figured it out.
This question is for Jason Anderson. If convicted on all charges, special circumstances, what could these people be facing?
They could be facing, three different things, depending on which direction we would go, and we haven't considered any of the directions. So, 25, 50 to life on determinate stuff. Special circumstances obviously would carry with it either life without parole or potential death penalty.
And each of them is charged with the same thing?
Correct. They are. Yeah.
Has your office decided yet whether or not it will pursue the death penalty?
No, sir.
I'm sorry, I need to clarify one more thing with Detective Martino. So Juan Perez, you said, owned the pallet company at the pallet company. Or can you clarify that a little more? It was on the property of the Torres and what?
Yeah, like I said, they own several businesses and properties, they being the victim and her husband.
Okay.
They own several properties, and so Juan leased a business from the victim and her husband.
So he was running the pallet company?
Correct.
So he was leasing the pallet company, they were the owners, but he was running it?
Correct.
Yeah, so if you didn't see it, here it is again. This is the victim, Yesenia Torres, coming out of the hamburger place. And then she goes to her car, but the other vehicle pulling up was waiting for her. So if you weren't paying attention, we'll just rewind it again. See right over here in the corner? There's this car waiting for her to come out. Basically stalking her. Almost like a Kohberger. You know? And here she comes. And doesn't look like the greatest parking job in the world. She gets about to get into her car, and then that guy comes out of the passenger seat with a silencer, but he doesn't shoot her right away, which is kind of weird. Like, what's he doing? And then he gets her purse, and I think the purse is to prove that they actually did it. Kind of like in the what the hell was that one? I said it earlier, in the dentist lady that was killed. Kendra Hatcher, they took like her purse so they could prove, or her phone or something, I can't remember what it was, but like look at her fighting over there. She's fighting, and the guy's already shot at her, and this guy does come out to help, but then he's being shot out. Now apparently he's a wimp. Whoever said that is an idiot. Does anybody think that guy's a wimp right there? What was he supposed? He was he was going to come over and fight that person, but a gun overwhelms that, because you can't beat a gun, right? So you're far away, he's going to get killed. So I think you're just a really shitty person when you said that up above, okay? So there's another version where I kind of zoom in a little bit, where you can follow her around, and that vehicle's starting to pull up. She's going to get into the car, and then here comes the guy get out of the passenger seat. Yeah, I thought he was actually the opposite of a wimp. He went running over there to physically fight this person. But as we all know, when there's a gun, that wins. But hey, if you guys are out there, if you can please help support the channel. I know every time we do these press conferences, etc., nobody, it's very rare when people support the channel. So if you could please do that, that'd be great. We've only got one coffee, one channel member. It's not, we don't have another struggling night. Last night turned out well at the end, so hopefully we can have another decent night. We're trying to get this month ended strong. Anyways, he's out there, he's falling around, and then and it's weird how he keeps missing on all of these shots. Like every one of these shots, he hasn't hit her yet from point blank range, and then right then he hit her. All right, so and then apparently she sort of hobbles over to the door, and then he comes over and gives her a fatal shot. So she's killed by that person. I mean, it must have been really scary at that point. All right, anyways, that's all I got on this one. Once maybe if we can get a hold of the probable cause in that case, that'd be really interesting too, to put it all together, map it out, get the timing. This is just brutal though. And it lasted for so long, just this weird, she probably doesn't even, she might barely even know who this person is, if she does at all. All right. All right, we're now switching over to the Idaho 4 case with the results of the hearing today. Or, the hearings, the results came out today. All right, so I'm going to do them in order that are put out there. All right, so here is the first one. Now, some of these are really long, so I don't know if we just skip around or, maybe there's some parts that are explaining what things are, but we're going to need to get the energy level up in here with the support from you guys to do these shows, all right? Because right now it's going to be reading again. It's the double whammy, press conferences and me reading. That's when everybody just goes, yeah. All right, so if you guys have the ability to, I would appreciate it. if you can't afford to help support the channel, you don't need to type in the chat how you can't afford it. It's almost like you're trying to, if you can't, then I don't want you to, but if you can, that'd be great. But you don't need to say how you can't in the chat. Nobody's wondering why you're, nobody's thinking, what about what's her face, Nobody thinks that way. Okay, but we're currently at 1 new channel member, 1 coffee, and we're at 1/5 of the goal currently, right? All right, here we go. Defendant is charged with 1 count of burglary and 4 counts of murder in the first degree in connection with the stabbing deaths of 4 University of Idaho students in the early morning hours of November 13, 2022. As part of law enforcement investigation, the federal FBI issued federal grand jury subpoenas to Apple, Amazon, etc. Before the court are defendants' motions to suppress the information obtained through the subpoenas and the AT&T, Google, Apple, and USB search warrants. Defendant argues the FBI's issuance of the subpoenas constituted a warrantless search that violated the privacy interests under both the Fourth Amendment and Article 1 and 17. Suppression hearings on the portion, defense motion. I just want to go down to let's do this one right here. Findings of fact. On November 13, 2022, an officer from the Moscow Police Department responded to a residence located at 1122 King Road in Moscow, Idaho, where he discovered the bodies of Madison Mogan, Kaylee Gonzalez, Ethan Chapin, and Xana Kernodle. Each appeared to have been stabbed to death. The investigation that ensued was a multi-agency affair involving members of the Moscow Police Department, the Idaho State Police, and the FBI, among others. For purposes, I'm telling you guys, this is what happens when I'm reading. You notice how even after I said that, it's just For purposes of the investigation, a command team consisting of several investigators from each of these agencies was set up at the Moscow Police Headquarters. The command team included, among other, Detective Brett Payne and Detective Lawrence Mowry of the Moscow Police Department, as well as Special Agent Nicholas Balance of the FBI, all of whom were, co-located on the second floor of the Moscow Police Department. The command team met twice daily for several weeks to review analysis. Yeah, and then it's Alley Cake. I appreciate it. We get this. A lot of times it's the same people supporting the channel. And it'd be nice if other people would help sometimes as well. But thank you, Alley Cake. The command team met twice daily for several weeks to review, analyze, and organize the information gathered in the investigation. Pertinent information was transmitted into a working probable cause affidavit that could be and was incorporated by law enforcement into their various search warrant affidavits. All investigators had access to the search warrant affidavit issued during the investigation. Among the initial search warrants sought in the investigation were two to AT&T, the cellular carrier, for phone numbers that law enforcement had linked to defendant. Detective Payne applied for and received both warrants on December 23rd, 2022. As Detective Payne was not an expert in cell phone data, he relied heavily upon Agent Balance, who is a member of the FBI. I think I remember this hearing when they were talking about this. He was a member of the FBI cellular or CAS team and specializes in cell records analysis. Agent Balance added Detective Payne. Hey, thanks, Susie Clue, for the coffee. Aided Detective Payne in both drafting the search warrant affidavits for the AT&T warrants and analyzing the returned information. Within a week of obtaining the AT&T warrants, law enforcement obtained a warrant for a defendant's arrest. The arrest was effected on December 30th, 2022, or effectuated, and it says at his parents' home in Pennsylvania. At this time, law enforcement seized defendant's cell phone pursuant to a search warrant for the home. To preserve the phone data, the FBI copied the contents of the cell phone onto a USB drive, but did not review the contents. Law enforcement also had a warrant to search defendant's vehicle, which was located in the garage of his parents' home. During the search of the vehicle, a receipt for an Apple iPad was found. Maybe I think if we read this thing, we might actually get new information, you know. Following defendant's arrest, the FBI obtained and served 2 federal grand jury subpoenas, one to Apple and one to Amazon. Let me ask you guys, if there's people out there that are pro-burgers, you know, think Kohberger is innocent, would it mean anything to you if he ordered on Amazon, a knife sheath, and it's the exact make and model as the one found on the bed? And then you have DNA found on that knife sheath and a white car driving around that law enforcement says is a white Elantra. At that point, aren't you convinced that Kohberger's the guy? If he ordered that exact same make and model of a knife sheath? Come on. Yeah, well, we've got 142 likes. See if you guys can hit that like button for me. That'd be great. Within a week of obtaining the AT&T warrants, law enforcement obtained a warrant for a defendant's arrest. The arrest was effectuated. Okay, we just said that. To preserve the phone's data, the FBI copied the contents of the cell phone onto USB drive, but did not review the contents. Law enforcement also had a warrant to search defendant's vehicle, which was located in the garage of his parents' home. During the search of the vehicle, they found the iPad. I think I just repeated that. Right here, first AT&T warrant. The first AT&T warrant, Detective Payne applied for, sought 9 categories of records associated with defendant's cell phone. You know, each of these categories are narrowed down by detailed description of specific information sought. The information requested was temporarily limited to 48-hour period, November 12th to November 14th. That was the cell phone data, and then eventually they expanded it out, and that's when they got those other 13 trips over there. Based on Detective Payne's search warrant affidavit, the magistrate issued a search warrant for a second sought therein. The warrant stated in relevant part, Brett Payne having given me proof upon oath this day showing probable cause establishing grounds for issuing a search warrant and probable cause to believe property consists of certain evidence regarding the investigation into the crime of homicide at 1122 King Road. Let's see. And it's associated with Kohberger's phone right there. I wonder what happens if you call that number. 509-592-8458. Does his voice show up on there? AT&T pen trap and trace warrant. Within hours of receiving the return of the first AT&T warrant, Detective Payne applied for a second warrant at AT&T, this time to obtain records associated with defendant's cell phone number for the prior 6 months, as well as the installation of a pen register and trap and trace device for the number. The records sought were called detail records with cell sites for the voice, SMS, and data connections. Thanks, Amber Maiden. Man, every time I read, is it my reading ability sucks? Is that why the super chats die down when I read, or is it just pure boredom? You know. Again, Detective Payne, search warrant affidavit set forth in great detail the circumstances of the crime and the scope and results of investigation as of that date. Based on my training, yeah, this is all, that's the conclusion that's in the probable cause document. Let's see. Let me see if, let's just see if the word sheath is in here somewhere. Is it in there? Doesn't look like it. Lawrence Mowry having given data compilation. I mean, I don't know if we need to read through this whole thing. It's pretty long, and I can tell it's not doing well in the chat. Let's see. Let me just see what happens at the bottom. Is there a conclusion? Order of defendant motion to suppress. So this is the order, right? Okay, so maybe we don't need to go over this one. Or does it say right at the bottom? Oh yeah, here it is. There's a conclusion at the bottom. So anyways, at the very bottom it says, based on the foregoing, the court denies the following. Defendant's motion to suppress regarding AT&T first warrant. Hey, thanks up there to Tumbleweed, and then also to Cheryl Moran. Not a prober. And it's me, Calamity. This is where I come when I'm looking for facts and common sense and logic. Yeah, this one I think is the most boring of all of the documents. I haven't read them yet, but let's just see the conclusion here and we'll move on to the others. All right. This one is based on the foregoing, the court denies the following. Defendant's motion to suppress AT&T first warrant. Defendant's motion to suppress pen trap and trace device. Defendant's motion to suppress Apple account, federal grand jury subpoena, and search warrant. Well, let's see if that grand jury stuff. What are is Dylan in here? Morton. Let's see. Following defendant's arrest, the FBI obtained and served 2 federal grand jury subpoenas, one to Apple Inc. and one to Amazon. The FBI, a federal grand jury subpoena upon Apple. Let's see. Alright, so anyways, the defendant motion to suppress Amazon account. See, they want the Amazon. Why would you care, by the way? Why would you care out there to get a subpoena? You know, like, why would you care to suppress an Amazon account unless there's something incredibly damning on that thing? The Amazon account federal grand jury subpoena. You want that one thrown out. Well, that was denied. But man, you got to wonder, right? Because we've heard that he purchased the knife sheath there. And what I asked a minute ago, would that affect any of you pro-burgers out there if he absolutely purchased the same make and model knife sheath that was found on the bed next to Madison Mogen's body? I'm just curious. I just want you to be intellectually honest with yourself. Hey, thanks, Kim Worth. I've been following, let's see, some true crime channels for a while, but this is the first one I've become a member of. Well, thank you. That was really nice to say. This is where I come when I'm looking for facts plus common sense and logic. Thank you, Gray. You curated great and helpful content for the people to seriously discuss these cases. Well, that's very kind of you. And then Cheryl Moran said, not a pro-burger. And then Tumbleweed, not bored. I don't know. Sometimes I get that feeling when I'm reading things. Defendant's motion to suppress Google warrants was also denied, and defendant's motion to suppress. So these are all denied, every one of these. See that right here? It says court denies every one of these things right here, okay? So unfortunately for the pro-burger nut jobs out there, you know, remember when we watched the hearings? We watched it and we listened to Ann Taylor just absolutely bumble and stumble around through there, and we correctly saw that when we were watching it, just going, what is she talking about? What in the hell is she talking? We were doing over the DNA and those other 13 points she had, and we just looked at it and we're just going, this is ludicrous. But when you listen to pro-burgers, they made it sound like Ann Taylor was really on it, man. She was working the judge. She nailed it, and that kind of thing. And it's just, no. It really wasn't even close. I got to be honest with you. Hey, thanks Susie Clue and Lisa Valenzuela. What did you send me? Downtown building maintenance standards. I don't know what you're sending me, Cindy. My God, you just sent me a link to nothing. You know, send me something that goes somewhere. You just sent me a link that goes to a website that doesn't do. I think you do that a lot, just to sort of. No, you didn't. You didn't send it to me, Cindy. It's not there. Here, let me show you what you sent. Right here, watch. That's what you sent me. See, I mean, there's links here, but you got to send me. Okay, these are the new ones. Hey, does that mean you win? Let me see. Hold on. Is there anybody else? Okay. You should send me this page so I don't have to think about it. Okay, so I have all these September ones. And is it this one? Is there 3 of them in here? Let's see. Well, I'm just going to download these really quick so I don't forget. Oh man, this is sweet. All right. Well, good. How did you find that one? Was it just a website, or you just stumbled upon it, or what? Because I tried to go to a website and I couldn't find it. All right, hold on. Working on ASHA degree. I'll just put it in there. Boom. All right. So I think we have to kind of start over on that. All right. I think you're probably already in my system, Cindy, but maybe send me an email with your address in it again. You win! Cindy wins! Even though she didn't send me right to the link. Apparently there's 3 of them, though. See if you can find the other 2. Maybe they're all combined in that, though. All right, so that we got that one. Now we're going to move on to the Frank's hearing request. And how long is this? This one's 38 pages. I mean, these things are like novels, every one of them. Let's see. A, defendant has not met his Frank's burden on issue 1 and 2, challenges Exhibit A. Okay, remember Exhibit A, they challenged it because of stuff like Dylan Mortensen, she said other things, but that wasn't in there, etc. In issues 1 and 2, defendant challenges Exhibit A, which is a probable cause statement that individual investigative officers appended to their affidavit in seeking search warrant. As defendant notes, Exhibit A was a working document drafted as a group effort among the multiple investigative officers working on the homicide investigation. In their respective search warrant application, the officers submitted and swore to Exhibit A as their own, even though it was a product of collective effort and not necessarily limited to the swearing officer. Defendant has not met his burden under Frank's on issues 1 and 2. First, it's not, let's see, what is 1? So number 1 was defendant challenges his approach, arguing that Exhibit A was treated as a wild card to easily get a warrant. And then number 2, he challenges alleged misrepresentations in Blaker Exhibit A. So that might be stuff like, that might be the timing of the vehicle over in Pullman, Washington. It also might be that, Dylan Mortensen said other things they claim, etc. We got trolls in here again. Yeah. Let's see. Defendant has not met his burden under Frank's on issues 1 and 2. First, it is not improper for law enforcement seeking a warrant to swear to matters within the collective knowledge of other officers involved in the same investigation. Second, defendant has not demonstrated in his proffers any misrepresentations or omissions, much less that they were made intentionally or recklessly or had any effect on probable cause. That's exactly what that female prosecuting attorney said. I wonder if these are just basically the same arguments that were made in court, just written, and these aren't, like the judge didn't write these, maybe. I don't know. I think maybe they did. So what's this next portion? Defendant has not demonstrated any impropriety in law enforcement execution of Exhibit A based on collective knowledge. Importantly, the exhibit, as challenged by defendant, included statements alerting the magistrate that the affiant was assisted by other law enforcement agents and that the information contained within the exhibit was based on... You know what we could do? Let's try to do this. Here, let's use the... this is going to be sweet. We did this once before. Let's see. Chat GPT. And this is sweet. Watch this. Summarize in great detail a PDF document. You want to do that? This is pretty sweet. They can do this like... And then you just load it in there. Let's throw this. This is the Franks. I'm going to put it in there. And let's see what it does. And then I can have like a voice read it over here.
The document is a court order from the District Court of the 4th Judicial District of Idaho, addressing the defendant Brian C. Kohberger's motion for a Franks hearing. Below is a detailed summary of its contents. Case background. Kohberger is charged with 1 count of burglary and 4 counts of first-degree murder. The incident in question occurred on November 13, 2022, at 1122 King Road in Moscow, Idaho. The victims were Madison Mogan, Haley Goncalves, Ethan Chapin, and Xana Knodel.
Kohberger filed a motion for Frank's hearing, arguing that law enforcement misrepresented or omitted material facts in their probable cause affidavit supporting 17 different search warrants. The state opposed the motion, claiming that Kohberger failed to meet the substantial preliminary showing standard under Franks v. Delaware Court's decision. The court denied Kohberger's motion for Frank's hearing, concluding that the search warrants were valid. The omission of investigative genetic genealogy IgG identification was not misleading but would have only bolstered probable cause. Kohberger failed to show that law enforcement knowingly or recklessly included false information or omitted material facts in their affidavits. Legal standards discussed. Franks v. Delaware 1978. The defendant may challenge a search warrant if they can prove that false statements or omissions were made knowingly, intentionally, or recklessly, and that such statements were necessary for probable cause finding. Idaho case law, for example. State v. Guzman 1992 extends Franks to omissions of exculpatory facts. The burden of proof is on the defendant to provide a substantial preliminary showing before a full evidentiary hearing is granted. Analysis of defendant's claims and court's findings. **1. Kohberger argued that officers misrepresented their individual roles in the investigation. The court found that it is standard practice for officers to rely on shared investigative knowledge and affidavits, and that this did not constitute a Franks violation. *2. DM was an eyewitness who saw a masked intruder in the home. Kohberger argued that her statements were inconsistent. She did not recognize him from a photo lineup after his arrest. The court ruled that DM's statements were largely consistent. Her inability to identify Kohberger was not exculpatory, as the intruder was masked. *3. Kohberger challenged how law enforcement identified his white Hyundai Elantra. He argued that the FBI specialist preferred a 2011-2013 model year range but later included 2011-2016. The Ridge Road footage used for vehicle ID was not the suspect's car. The court found that vehicle ID process was reasonable. The FBI analyst's expansion of the date range was not misleading. There was no evidence that law enforcement knowingly used incorrect footage. *4. Kohberger claimed that the search warrant affidavits falsely presented the timeline by suggesting law enforcement identified him through vehicle tracking rather than IgG DNA analysis. The court ruled that the timeline was not misleading, even if IgG played a role. Including IgG would have strengthened probable cause, not weakened it. *5. Kohberger argued that law enforcement misrepresented his cell phone's movements on the night of the murders. The court found that the cell site location analysis C-slide was properly interpreted. Even if errors existed, they were not intentionally misleading. *6. Kohberger argued that law enforcement omitted key details about a dog barking at the scene, which might suggest another person was present. The court ruled the dog could have moved inside the house through an open door. There was no proof that someone brought the dog inside. Final ruling. The court denied the Franks hearing, concluding that none of the alleged falsehoods or omissions undermine probable cause. Kohberger failed to meet his burden of proof. The search warrants remain valid, and no evidence is suppressed. Conclusion. This ruling significantly impacts Kohberger's defense as it upholds the validity of search warrants that led to key evidence DNA, vehicle tracking, cell phone data. The decision blocks Kohberger from challenging the admissibility of this evidence at trial.
Ah, God, isn't that amazing, you guys? Kohberger is screwed. But by the way, what a great summary that was. I mean, don't you think that's amazing that we have this technology? Just something that, like, boom, boom, boom. And now it makes me want to go back and look through and look at some of the Dylan Mortensen stuff that they were talking about. Hey, thanks, K-Me, and also Heather, like the 3 R's at the end, and Susie Clue, and Allie Cake. And you guys, we only have one new channel member tonight. So if somebody out there wants to gift some channel memberships, we got a ways to go before I can gift 5, but that would be awesome. So how about we can go look at, let's go look at Dylan in here. She's got to be in this, right? Or is it like Mortensen? No, this isn't the, we need the Frank's hearing. Huh, how did her name get in there? Huh. How did they break that down when the name Dylan isn't even in there? Or is it? Let me try to scan. They did their own scanning for OCR. Let me see if I can do it. I'm going to go through each page. Thank you, Joel Burnt and Amy Lemoyne. Very cool, very cool. I mean, it did that breakdown mention Dylan Mortensen, right? Let me see. How did he say it though? It was up here. Cell phone data. Suspect vehicle. I think it was right above there. Witness testimony DM. Okay. That's what we're looking for. Alright, right there. Defendant also contended that law enforcement misrepresented statements made by DM that would have demonstrated her unreliability. These allegedly false statements and omissions, according to the defendant, were exculpatory and material. They weren't exculpatory. See, that's what's so weird. They always use the word exculpatory. How is it exculpatory? It just means that, I mean, it's not exculpatory at all. I mean, there's nothing exculpatory about it. That means that what she's saying would have helped him in some way. You know, it's garbage. DM statements that her memory were fuzzy. Okay, so it says right here, DM accounts were remarkably consistent throughout her multiple interviews with law enforcement, and further, the probable cause affidavit are very consistent with her accounts. Second, DM, see, this just shows you what liars, like when people like Ann Taylor get up there and just start mumbling around, it's garbage. So right here it says, while defendant's challenge may be fodder for cross-examination, it is not the proper subject of a Frank's motion. Defendant's own proffer establishes that DM, Dylan Mortensen's accounts, were remarkably consistent throughout her multiple interviews with law enforcement. And further, the probable cause affidavit are very consistent with her accounts. Second, Dylan Mortensen's interview statements that her memories were fuzzy and dreamlike and may have been affected by being tired or under the influence of alcohol do not call into question her reliability to the extent Franks would require disclosure. Finally, Dylan Mortensen's failure to recognize the photo of defendant is of no consequence given that the intruder she saw was masked. Exactly. That's what we just said a minute ago. I mean, it's just ridiculous. You know, the draft Exhibit A circulated by law enforcement included the following descriptions of statements. Dylan Mortensen made statements during interview that indicated the occupants of the King Road residence were at home by 2 and reportedly asleep by 4. This is with the exception of Kernodle, who received a DoorDash order at the residence at 4 a.m., at approximately 4 a.m. Dill Mortensen stated she was awoken on approximately 4 a.m. by what she stated sounded like Gonzalez. I mean, it's weird. Every time I read that, I'm like, what? Yeah, Gonzalez, Kaylee Gonzalez, playing with their dog in one of the upstairs bedrooms, which were located on the 3rd floor. A short time later, Dylan Mortensen said she heard who she thought was Gonzalez say something to the effect of, "There's someone here," but a review of the forensic records associated with the download of Kernodle's cellular phone indicated she was likely awake and using TikTok app at approximately 4:12. And interestingly, that's only within a couple minutes of the time that Kohberger would be entering the house. Dylan Mortensen stated she looked out of her bedroom but did not see anything when she heard the comment about someone being in the house. I mean, we've already gone through all these. All right. So what's this? Let's see if there's anything new that they snuck in down here. When the exhibit as were submitted in support of search warrant, Dylan Mortensen had sat for at least 3 interviews with law enforcement, 2 on November 13th, 2022, 1 with Officer Nunez, and later with Detective Mowry. At 1, and then it says, and 1 on November 17th, 2022 with Detective Gooch. Her description of the intruder was notably similar during all 3 interviews. And it says 1 white male. So this is cool. Now I think this is sort of new stuff for us, right? A white male, slim, skinny, lean body. Although this was in that hearing, I think. Slightly taller than Dylan Mortensen, about 5'10", wearing all black, wearing a mask that was covering his forehead and mouth. His forehead and mouth? How does that work? Oh, wow, so it's like a balaclava. Jesus Christ. This guy had a balaclava on. But she could see that he had bushy eyebrows, though. Isn't that wild? And mouth. Let's see, what does that look like? Hold on a second. I said that, Moofies. Why'd you type it in? I said it out loud. Yeah, so that means he had this one right here. Look at that. That's what he was wearing. And then you could see that he had bushy eyebrows right there. What do you mean the Lord's name? What do you mean, Tim? Did you say something? Yeah, we knew about the bushy eyebrows before it was even out there in the public. She didn't say it before me, Michelle Perkins. You guys are about 20 seconds behind me. So maybe you think that, but... No, you didn't type it in right before. I get what you're saying. From your perspective, you think that, but you guys are on a 5 to 20 seconds behind. So when I say balaclava, and then like 15 seconds later somebody types it in, I go, oh wow, that's weird. Yeah. So from your perspective, though, you're so far behind that it feels that way. Well, they've been allowing everything in court recently, so... Yeah, let's see. The intruder walked out towards the back, so wearing all black, wearing a mask that was covering his forehead and mouth, a voice she didn't recognize saying he was here to help. See, now they're admitting, right here, you guys. Didn't I tell you guys that the person who said here to help is not Ethan Chapin? And we've all known that because it's logic. But now they're basically saying that as a fact in here. See that? A voice she didn't recognize saying he was here to help, and 7, yeah, they have like a to have like things like you have to have a long delay if you have things like the words that show up on the screen, CC. I don't necessarily have that, but then there's different settings you can have, and even the one that's the closest, there's still like a 10-second delay. So that's why it's sort of frustrating trying to have a conversation sometimes. You say something and then, you know, nobody responds for 25 seconds or something, and you're just sitting there wondering what the hell's going on. It's crazy. Let's see. While she did not tell, okay, the intruder walked out or towards the back sliding door without saying anything to her. While she did not tell Officer Nunez that she noticed the intruder carrying a vacuum-type object in his hand, she did convey that information to Detective Mallory later. Wow, what's this vacuum-type object? What is she talking about? Let me see. Wearing all black, wearing a mask that was covering his forehead and mouth, a voice she didn't recognize saying he was here to help. The intruder walked out or towards the back sliding door without saying anything to her. While he did not tell Officer Nunez that she noticed the intruder carrying a vacuum-type object in his hand, she did convey that information to Detective Mallory later that day, as well as Detective Gooch a few days later. Well, what are you talking about, though? She also told Detective Gooch that she remembered the suspect eyebrows were bushy, but could not remember their color. Detective Mallory, she could not remember the color of his eyebrows. What is this vacuum-type object? Like a big item like that? I mean, that's wild. More importantly, not only are Dylan Mortensen's statements consistent with each other with regard to the intruder description, they were accurately included by law enforcement in exhibit as set forth above. There's no one statement. You guys, we're still at one new member tonight. So if you guys are out there, if you could buy some members for people that can't afford them, and perhaps do the coffees, and let's get the super chats rolling. We got the end of the month is coming quick. It's a short month. Let's see, bushy, but could not remember their color. Yeah, so down here it said, there is not one statement in the affidavit regarding the intruder that cannot be traced directly to Dylan Mortensen's word. Consequently, defendant has not demonstrated an intentional or reckless false statement or omission of a material exculpatory fact with regard to law enforcement recounting Dylan Mortensen's description of the suspect. Well, we haven't heard that comment, though, right? Like the one about the vacuum cleaner looking thing. While she did not tell Officer Nunez that she noticed the intruder carrying a vacuum-type object. What does that mean? Something that big? He did convey that information to Detective Mallory. I mean, it doesn't seem like he would have brought that in with him. I don't know. That's just really bizarre stuff right there. Defendant also asserted that Exhibit A watered down Dylan Mortensen's statement about hearing Kaylee Gonzalez around the time of the homicides. According to the defendant, Dylan Mortensen was unequivocal in her 3 interviews when she reported that at approximately 4 a.m. she heard Miss Gonzalez walk upstairs with her dog before running back down the stairs saying, "Someone's here." And it says, in Exhibit A, however, law enforcement represented that Dylan Mortensen said she heard who she thought was Gonzalez. So, right, so like I said before, it was one of the 2 girls upstairs, and it didn't make sense because they were both found dead upstairs. So why would Kaylee be running down the stairs and then back up? Defendant argues the addition of the word thought is false, and further, defendant surmises it was intentionally false to cover up the fact that Dylan Mortensen was wrong about what she heard. Defendant points out that Miss Gonzalez was killed in the upstairs bedroom where she was found the next morning. Thus, it could not have been her who Dylan Mortensen heard running down the stairs at 4 a.m. Well, that's not necessarily true, though, right? I mean, the killer didn't make it into the house until 4:08. So maybe you could see somebody, it might have been 4:05 or not even that, like 4:08 when she said, "Hey, there's somebody here," and saw a car parked outside. Defendant contends that Dylan Mortensen misperception, had it not been covered up by law enforcement, would have cast doubt on her reliability and therefore probable cause. Thanks, Richard Watts. And we're currently at about 50% of the nightly goal, so if you guys could please help support the channel tonight, let us get to that goal. I would appreciate it. We always have these long lulls for some reason. However, the statement challenged by defendant can be read in two ways. That Dylan Mortensen said, "I think it was Miss Gonzalez," which is how a defendant apparently reads it, and which it claims is inconsistent with Dylan Mortensen's interview statements. That Dylan Mortensen said she heard Miss Gonzalez, but law enforcement had reason to think it could have been someone else. When the statement is viewed in context, the latter makes more sense. In their respective exhibit, as Detective Payne and Sergeant Blaker immediately followed up on the challenge statement with the following: a review of records obtained from a forensic download of Kernodle's phone showed this could have also been Kernodle, as her cell phone indicated she was likely awake and using the TikTok app at approximately 4:12 a.m. Bates at, Payne Exhibit A at Bates 5161. I don't know. Blaker, through the explanation, Payne and Blaker are effectively conveying to the magistrate why they believe Dylan Mortensen's statement of who she heard was questionable. Thus, the court cannot conclude there is anything false or misleading in this regard. Exactly. In addition, even assuming it was a false statement, defendant has not established that it was an intentional or reckless attempt to hide Dylan Mortensen's alleged misperception of, or that her actual statement was exculpatory or other material to probable cause consequent. Hearing is not warranted with regard to statements in the relevant exhibit as regarding Dylan Mortensen's account of what she saw and heard. Defendant next asserts that the probable cause statement omitted important information bearing Dylan Mortensen's reliability. Defendant notes that Dylan Mortensen qualified her interview statement on several occasions by questioning her memory of that event. For example, she told Detective Mallory everything was kind of blurry, like I don't fully remember it, I would say. Yeah, let's see. And I believe I was also very drunk. See, this is a few days later. These are things we haven't heard before. These are direct statements out of her interviews. So right here it said, a few days later, while recounting the events to Detective Gooch, Dylan Mortensen stated, "Again, I believe I was also very drunk. I don't know how much of this is real. Like, I don't know if my mind was like doing whatever. I don't know any of it. Like, half this stuff, I don't know if it's a dream or it's real. I just have no clue." She also said her memory was fuzzy and cloudy, and she could not differentiate if anything is real or anything is a dream. The information was not included in the exhibit. All right, you guys, I'm going to have to start doing like dancing a jig or, toss myself in prison to get up to where we need to be for tonight. All right, let's see. The law does not favor defendant On his argument, probable cause is determined by examining the totality of the circumstances, making practical, common sense decision. Well, yeah, I mean, when we were listening to all of this in the hearings, it just is, it's garbage, okay? And let's go back to the breakdown. What was the other point? So you had Dylan Mortensen, and then 3 was, okay, suspect vehicle. I want to see what they say about that. Surveillance video. There was other evidence included in exhibit as, let me go down here, Mr. Kernodle's room and a male voice speaking. It was shortly after this she opened the door for a third time and saw the suspect walk by her towards the sliding glass door, which corresponds with the surveillance video showing the suspect vehicle leaving at approximately 4:20. Alright, you guys, we're now in prison because Alley Cake threw me in there. It's unfortunate. I must have been mean to somebody earlier. Who knows? So there we are, you guys. We're stuck in here now, unfortunately. So who's getting me the hell out of here, huh? Yes, in shock. Frozen shock phase. So, you guys have to get me bailed out of prison here for me to get back to these documents. We'll get to those in a minute. But we got to get the hell out of prison first. And I was tossed in there by Tumbleweed and Alley Cake, who put the dreaded prison bar symbols up on the screen. And the only way to get out is to be bailed out. And unfortunately, we need to be bailed out because we got stuck on, like, I don't know what you call it. Let's see. Well, there's Alley Cake. She bought me some ramen. Got some top ramen coming my way. But that's not bail. That's not bail at all. What time is it? Alright, we got Moofy's bail. We got $2 for bail now. What else we got? That's not going to get me out of prison. Yeah, they just got creamed. I might go through all of this, like, kind of with a fine-tooth comb to see if there's information, because there's some stuff that we've never heard before, really. Defendant's proffer does not show the FBI specialist's identification. Okay, you guys can't see it. Alright, look at that. There's Heather. We got It's Me Calamity. We're barely even scratching our bail tonight. The bail's, I don't really have a number, but we're definitely not at the bail amount to get out of here. We got ramen, and altogether we're at $10, so that doesn't get me out of prison. You know, we gotta bribe the guard to look the other way, get a cake in there with a file in it. I think a lot of the new people that watch the channel don't really like... See, on this channel, every single night, I try to raise funds to help support the channel to allow me to keep doing the shows, but we also give away thousands of dollars at the end of each month to various true crime-related charities. We have a DNA fund and a scholarship fund. So the only way that happens is if, on a nightly basis, when you have 300 or some people watching, it seems like it should be really, really simple to reach goals, and for some reason we struggle some nights. It really shouldn't be that way. I mean, I'm spending 3 hours doing live streams, getting ready to do the live streams during the day, and putting out videos for you guys to watch. And that's what my job is. So what it would be great is if when people watching, we're out there supporting the channel during the show so we can continue to do what we're doing, because when we do these live streams, there's no ad revenue. It's almost ridiculous. I don't know what they use for, but it's, if there's $20 that come in on a 3-hour show for ad revenue, that's a good night. Well, there you go. Thanks, Heather, and thanks to Detective Wisdom and Cheryl Moran again. See, look at that. And there's GSU PM. All right, so that's good enough. I think I got out. We're standing out. We're just going to wait for a cab. I don't have any money for the Uber or anything like that, or a hotel, but, we'll just start camping somewhere. Hey, thanks, Persis57. All right, there we go. Hey, we got out. Boom. Thanks, guys. Appreciate it. And look at that. That was the fifth super chat on the live stream. So let's see what it says in here. I'm curious about this Ridge Road thing. And by the way, where is that? Yes, that's back here. So you drive around. I guess Willanta Drive is really kind of Ridge Road also, because it goes around like this. So back here is Ridge Road. So what is it saying about this in here? Thanks, Kim Worth. Very cool. So here we go. And by the way, if you're not aware, my channel's given $230,000 out since January of 2020. So we actually walk the walk over here. I'm not making something up. I show every nickel on the screen and prove every single nickel that's been sent out, and everybody that's been here all those years knows exactly that what I just told you is the truth. All right. Defendant's next challenge, Exhibit A, on grounds that the FBI vehicle specialist identification of suspect vehicle 1 as a 2011. I get so angry when I hear people that are bitching and moaning that the FBI originally said 2011 to 2013 and then changed it to include 14, 15, and 16, and they act like there's something inherently wrong with doing that. And what kind of brain do you have? It's just such a weird thing to even think about. It never even crossed my mind. It doesn't mean a damn thing. It's just, the expert came up with it and went, well, you know what? It actually could be 15, 16, or 7, 14, 15, 16. I just don't understand the sort of hand-wringing over that piece of information. It's bizarre. I'm really strange that people feel that way. Do you guys know you guys feel that way at all? It's really bizarre stuff. Okay, let's see. So it said the vehicle 1 was a 2011 to 2016 Hyundai Elantra, was based on video footage from Ridge Road that law enforcement knew or should have known was not suspect vehicle 1. Defendant stated that he knows law enforcement based its identification of the vehicle on the Ridge Road footage because we have the emails from the FBI specialist who explains on November 23rd, 2022, that their team is mainly looking at the window configuration. Yeah, remember that? The window. Didn't I tell you guys that they can trade out the windows in a 2011 all the way to 16? See, I found that on my own, and that's why they did that. So they're basically looking at the window configuration, something these other images do not. But later that day, an FBI agent sends them images from the video, calling it a great one. However, defendant proffer does not show the FBI specialist identification was in fact made on the Ridge Road footage. The FBI emails defendant contends support his position contain no mention of Ridge Road. See, look at how lame Ann Taylor is. Just trying to assign it to this Ridge Road thing, but that's not even, it never even mentioned that that's the footage. See right here it says, however, defendant proffer does not show the FBI specialist's identification was in fact made on the Ridge Road footage. The FBI emails defendant contend support his position contain no mention of Ridge Road footage and no mention that the FBI was mainly looking at the window configuration. It says defendant asserts that the email stating, "Got a great one," attached images from the Ridge Road footage. Say Ridge Road. Say Ridge Road footage 3 times fast. You can't do it. Ridge Road footage. Ridge Road footage. It's the same as hyoid bone. Say hyoid bone 3 times fast, and if you say you did it, you're a liar. Okay? Gray, I did it. How dare you call me a liar, you bastard? Oh, God. Well, thanks, Moofies. And sorry, when I have the delay, it's hard. Sometimes I think, I got to remember that you guys are like 15 seconds behind me. Got me looking stupid, Gray. On what? Which one? I don't even remember what I just said. I started thinking of something else. However, defendant proffer does not show the FBI specialist identification was in fact made on Ridge Road. The FBI email defendant contends support his position contained no mention of Ridge Road footage and no mention that the FBI was mainly looking at the window configuration. Saying things 3 times faster. Oh, a hyoid bone. Yeah, you can't do it, man. Yeah, there's no chance. But what was the other one? Ridge Road footage. Come on, try to do that one. Ridge Road footage, Ridge Road footage. I start saying Ridge Road footage. Ridge Road. See, it's even hard to say Ridge Road 3 times fast. You know what I'm saying? Yeah, footage. Gray, I really did. You see, I was a linguistics major, and I don't give a damn, okay? You couldn't say it. Let's be honest. See, that's an arrogant, Gray. You're a narcissist. I mean, how do you know I couldn't say it perfectly, you bastard? Oh, God. And by the way, when I do that little voice thing right there, it's from experience reading the comments by the nut jobs that show up in the comments section of my videos. So that's really just experience. It's not... Plus, don't you guys love that voice? The whiny voice. I mean, who doesn't like that one? Come on. I don't, Gray. I hate it when you do that. Because I always think you're talking to me. Maybe I am. Okay. Maybe I am. Oh, shit. Okay. See Exhibit D9. Defendant asserts that the email stating, "Got a great one," attached images from the Ridge Road footage, but there is nothing in the proffer establishing that images were in fact attached, and importantly, what those images were. At Bates 1582, at the pre-Franks hearing, the court inquired further into defendant's support for his position that the identification of suspect vehicle 1 was based on Ridge Road footage. Counsel again referred to the FBI emails and unlabeled screenshot reproduced on page 17 of defendant's amendment memorandum that defendant claims were from the Ridge Road footage. This is insufficient to establish beyond speculation. The Ridge Road footage was the basis for the identification. Even assuming it were, however, defendant has still failed to carry his burden under Franks. And by the way, you guys, how come we're still only at 1 new channel member tonight? Man, you guys, let's get going there. Your whining is so gross. I'm unsubscribing, Gray. Hey, no name, we don't care, okay? You're no name to us. We don't care. Okay, do you get it? Thank you very much. Let's see. Even assuming it were, however, defendant has still failed to carry his burden under Franks. Because the vehicle identification came from the FBI, which was disclosed to the magistrate in the exhibit, as there is a presumption of reliability. Defendant has not met his Frank's burden on issue misleading timeline. Okay, I want to see, this is the part about, it was really 254 or whatever the hell it was. Let's see what it says here. Defendant claims that law enforcement created a false narrative of their investigative timeline in Exhibit A, so as to make it appear that the defendant was... We've already done the summary of this, by the way. I'm just going back to the important parts. These are the trolls, by the way, showing up in the background. So make sure to keep... Every time there's one of these people that make the comments, you can always tell, too, if you click on their name and you go look at their profile, almost every single time it's something that was created within the last week. But great! Alright, guys, let's get some new channel members tonight. Come on! You can do it. You can do it. Let's see. As to make it appear that the defendant was identified through their investigative effort and not, in fact, through IGG. In other words, he argues that law enforcement, having already identified the defendant through IGG, tailored their Exhibit A to support... I knew that's what all of the Kohbergers think, that Exhibit A was tailored based on the IGG investigation. And I guess you could say that some of it, obviously they looked into Kohberger, but it's not like tailored to it. They're looking into Kohberger. Timeline about the identification, but these examples fall short of the Frank standard. First, defendant notes that in Payne Exhibit A, Detective Payne states that on November 29, 2022, officers from the Washington State University queried where Hyundai Elantras registered at the school and pulled up a 2015 white Elantra with Pennsylvania plates that was registered to the defendant. That same day, Detective Payne states another WSU officer was patrolling the area by a defendant's apartment and located a 2015 white Elantra with Washington plates. He ran the plate and it returned to defendant. ID defendant points out that Detective Payne was not even aware of the WSU officer's finding in this regard until December 20th, 2022, after defendant was already identified by IGG. Yeah, I mean, the thing is he's November 29th. I told you guys the same thing when we went over this. November 29th is way before he was identified. So they were doing random queries and came up with Kohberger. And once they got his name, that's how, when they went back to look it up, they realized that he was queried and his name showed up even before. So when you read it, you're not thinking, the defense is being misleading when they try to make it sound like they're just going back in time. For example, when he was pulled over months before the murders, they have video of that. It's the same kind of thing. It's just once his name showed up, you start looking at how his name showed up in the system. Hey, all right, Patricia Selby became a new member. Now, what I'm looking for are people to buy memberships for the people who can't afford it in there. We're currently still 17 short of the lower goal, but if we get $67 more in tonight, then I'll gift 5 memberships. So maybe we can try to work on that as we work through the rest of these documents. First defendant notes that in Payne Exhibit A, Detective Payne states that on November 29th. So this, you guys get what I'm saying? Like these, remember when they said, hey, we're looking for a white Elantra. So these officers on their own just looked it up and they found the Elantras and they put it into their system that they found the Elantra, an Elantra, and it was Brian Kohberger's. And then way after that, so what down here it says, the defendant points out that Detective Payne was not even aware of the WSU officer's findings in regard until December 20th, after defendant was already identified by IGG. Right. That's because there were other people likely that had Elantras too. However, that just sort of live in the area. However, he contends Payne Exhibit A makes it appear that defendant was identified in part through the WSU queries. No, that's not at all. They just go back and they mention that because they want, they're saying that, yes, he drove a 2015 white Elantra, and here's a record of it. Hey, thanks, Sandy Shirley. Detective Payne later points out that defendant registered his 2015 white Elantra with Washington State on November 18th, 2022. Don't you find that interesting? That he registered it with Washington State 5 days after the homicide? He noted that previously the vehicle was registered in Pennsylvania, which, unlike Idaho and Washington, does not require a front license plate. Bates 5167. Defendant contends that although Exhibit A makes it appear that law enforcement was focused on the lack of a front license plate early on, it was not until after he was identified through IGG that it became an object of inquiry. In neither example has defendant established Detective Payne investigation timeline to be misleading or false, much less intentionally or recklessly so. There can be no question that defendant was identified in part through the WSU officer's queries and through the suspect vehicle's lack of a front license plate as observed in surveillance video. You guys, there it is. There's the answer, everybody. It's right there. Finally, we know for certain. So it says right here, it says, there can be no question that the defendant was identified in part through the WSU officer's queries and through the suspect vehicle's lack of a front license plate as observed in surveillance videos from the night of the murders. Can I get a boom? All right, thank you. Hopefully I'm reading this right. If not, we'll unboom it. The fact that law enforcement had additional DNA evidence tying defendant to the crime does not render it improper for law enforcement to rely on independent evidence accomplishing the same. It would arguably be irresponsible for law enforcement to rely solely on the DNA evidence without making an effort to corroborate it, particularly given the novelty of IGG defendant. Yeah, and see, that's just it. You wouldn't just go, well, he's got DNA. Okay, there you go. They did all the other stuff, too. He has a vehicle that's missing its front license plate. Yeah. It would arguably be irresponsible for law enforcement to rely solely on DNA evidence without making an effort to corroborate it, particularly given the novelty of IGG. Defendant has not established there is anything wrong with this approach. Observing that requirements under Franks that search warrant affidavit be truthful and complete does not require that every fact recited therein be correct or that every detail investigation be proven or be provided. Indeed, what is important to probable cause is the totality of the evidence once all gathered and examined in light of what that collection of evidence shows, not looking at it in isolation as each piece of evidence was separately gathered. Moreover, had law enforcement indicated in Exhibit A that the WSU query and lack of a front license plate only came across the radar after the defendant had been identified through IGG, defendant has not, let's see, what does it say? Moreover, had law enforcement indicated in Exhibit A that the WSU query and lack of a front license plate only came across its radar after defendant had been identified through IGG, defendant has not explained how this would have eroded probable cause. Indeed, as discussed below, including the IgG evidence, would have provided more, not less, probable cause supporting the search warrants. Let's see, in this issue, defendant challenges omissions pertaining to the barking dog referenced in the pain exhibit. God, the barking dog argument is the stupidest thing I've ever heard in my life. Wow. The defendant contends that Detective Payne failed to include 3 allegedly important pieces of information pertaining to the dog. The dog heard on the security camera continued to bark for 30 minutes after the suspect left. You mean like a dog that maybe knows that its owner isn't alive? That Detective Payne conducted a test to determine that the dog was likely outside. Hey, thanks, Cheryl Moran. You've been really sportive tonight. I really appreciate it. Thank you. Very kind, very kind. Look at that. We got Jenna. It was me, Mark. I haven't seen Mark in a while. J.D. Wells and Firefly. According to the defendant, this omitted information would have revealed that whoever was in the house brought the dog back inside after the suspect vehicle left. That's so stupid. Where you come up with it? So it says that Detective Payne conducted a test to determine that the dog was likely outside while barking. Let's see. That the dog heard on the security camera continued to bark for 30 minutes after the suspect left. That Detective Payne conducted a test to determine that the dog was likely outside while barking. And 3, that Murphy was found without any blood on him, even though the bedroom doors were open where the decedents were found. According to defendant, this omitted information would have revealed that whoever was in the house brought the dog back inside after the suspect vehicle left. According to the defendant, this omitted information, I don't know how that does anything. He further argues this information is material and exculpatory because it undermines the narrative and timeline that supports probable cause. However, defendant arguments assumes without proof there were no doors left open in the home after the suspect left. However, defendant argument assumes without proof. See, didn't I tell you guys this the other day? How do we know the doors weren't shut and a roommate opened the door, or one of the people in the house looking to see where the victims were, opened up Kaylee's room? We don't know. I said this. So it says, however, defendant argument assumes without proof there were no doors left open in the home after the suspect left. This assumption is not only speculative, but contrary to evidence in its proffer that the sliding glass door to the residence, the same door towards which Dylan Mortensen reportedly saw the suspect walk, was left open. Thus, if the dog heard barking was in fact Murphy, it could well have been back inside. Well, that is kind of interesting. Maybe the dog did go outside for a little bit, and it was barking. It ran down the stairs and, barked at somebody outside and then came back in. Who the hell knows? I never even have heard this speculation about Murphy being outside or anything like that before. Have you guys? And let's see. Well, could have. Let's see. Thus, if the dog heard barking was in fact Murphy, it could well have come back inside through the open door and gone into Miss Gonzalez's room on his own, where it evidently remained. There is simply no evidence to adopt defendant's speculation that someone brought Murphy inside after the suspect left the residence. Consequently, defendant has not shown that the fatal... It almost seems like they're saying that Murphy was outside. All right, guys, we're currently 15 short of our goal, the lowest end of the goal. So if you guys could help support the channel, that'd be great. But if we get another 65 in, then I'll donate 5 memberships of my own to people out there that don't have them. All right? So that's the goal for you guys for the rest of the show. Defendant has not shown that the failure of law enforcement to so speculate was a material and exculpatory omission that was intentionally or recklessly excluded. Issue 7, insofar as discusses data from defendant's phone. Hey, thanks, Mark. And conclusions drawn therefrom, he asserts that Exhibit A falsely implies defendant's location on the night of the murders based on improper speculation, misrepresentation, and omissions about 4 topics: the geofence return, the timing of the second AT&T warrant, the time defendant's phone stopped reporting, and the cell tower coverage. Defendant proffer on each of these topics is insufficient to warrant a Franks hearing. Defendant first takes issue Detective Payne's assertion regarding the geofence return. In Payne's exhibit, Detective Payne informs the magistrate that a query of the 8458 phone, Kohberger's phone, in these returns did not show the phone utilizing cellular tower resources in close proximity to the King Road residence between 3 a.m. and 5. Right, because it was turned off. It's just so stupid. You know, based on my training and experience and conversations with law enforcement officers that specialize in utilization of cellular telephone records as part of investigation, individuals can either leave their cellular telephone at a different location before committing a crime or turn their cellular telephone off prior to going to a location to commit a crime. This is done by subjects in an effort to avoid alerting law enforcement that a cellular device associated with them was in a particular area where a crime is committed. Right, they went through that. Defendant contends that Detective Payne claims that criminals will turn off or leave their cell phone elsewhere before committing a crime is highly speculative and conclusory. He argues that it is just as likely the phone was not present in the area. Defendant has not demonstrated the statement was deliberately or recklessly false. What Payne Exhibit A shows is that Detective Payne, based on his training and experience, drew one conclusion about the lack of a return to the exclusion of other possibilities. While there certainly may be other reasons for the lack of a return, the mere fact that the affiant did not list every conceivable conclusion does not taint the validity of the affidavit. Further, Detective Payne's conclusion was expressly based on his training and experience and conversations with other experts, which further belies any suggestion that it was deliberately or recklessly false. Man, this judge is like, he's awesome. You know, really accurately depicting the nuttiness of Ann Taylor. That doesn't say it, though. It's just all these things. They're not even close. But anyway, let's see if there's anything else in this document here. Suspect vehicle identification. We did that. Dog barking. Okay, so we did all that. So let's we're going to move on to the next one. So that was the Franks hearing. Let me see what this one is. All right. This is the detailed summary of the court order on Brian.
Detailed summary of the court order on Brian Kohberger's motions to suppress. This court order from the District Court of the 4th Judicial District of Idaho addresses 6 separate motions to suppress filed by Brian Kohberger, the defendant in a high-profile murder case. The court denied all suppression requests. Case background. Charges. Kohberger faces 1 count of burglary and 4 counts of first-degree murder related to the November 13, 2022 stabbings of 4 University of Idaho students. Arrest. Kohberger was arrested on December 30, 2022 at his parents' home in Pennsylvania. Search warrants executed. Pennsylvania. His parents' home, his person, and his vehicle were searched. Washington. His Pullman, WA apartment was searched. Idaho. Upon his return, authorities obtained a warrant to search his person. Defendant suppression arguments. Kohberger's legal team sought to suppress evidence from these searches on multiple grounds, including Frank's violations, false/misleading search warrant affidavits, illegal use of investigative genetic genealogy (IgG), evidence obtained through prior unlawful searches, failure to comply with the knock and announce rule during his Pennsylvania arrest, unlawful interrogation, and Miranda violations. The court had already ruled against the first three arguments in separate orders, leaving only the knock and announce issue and Miranda claim to be decided in this order. Key court findings. The court held a suppression hearing on January 24, 2025, where testimony was taken from Detective Corporal Brett Payne, Moscow PD, Detective Lawrence Maury, Moscow PD. The court found both detectives credible and reliable. **1. Claim. Kohberger argued that the Pennsylvania State Police PSP and Special Emergency Response Team CERT illegally executed a no-knock raid at his parents' home, justifying suppression of the evidence found. Court's findings. Law enforcement did attempt to knock and announce, but entry was expedited due to exigent circumstances. Factors supporting the decision. Destruction of evidence. Surveillance showed Kohberger awake at 1:09 a.m. in the kitchen wearing rubber gloves, handling a plastic baggie, and turning on lights in the garage where his car was stored.
Oh man, this is sweet, you guys, because I'm gonna go back and find that portion. But this proves that that stuff that was in those articles, even the one I put out, the video I did yesterday, it shows this part. So this is real, you know. It's not like this guy just said it out there and it wasn't something that was real. This is right here.
Authorities believed he might be destroying evidence. Safety concerns. Kohberger was suspected of a quadruple homicide using a knife. Authorities knew he owned a Glock handgun. Given the brutal nature of the crime and potential for armed resistance, a rapid entry was deemed necessary. Potential for escape. His car was in the garage, meaning he could have fled if given time. Legal analysis. Idaho and Pennsylvania law allow knock and announce exceptions for exigent circumstances, for example, risk of evidence destruction or officer safety concerns. The court distinguished this case from State v. Ramos, where officers rushed entry without true exigency. The court ruled that officers acted lawfully, and suppression was not warranted. *2. Claim. Kohberger argued that his statements made after arrest should be suppressed because he was not properly Mirandized. His statements were fruit of the poisonous tree derived from an unlawful arrest. Court's findings. Kohberger was properly Mirandized before interrogation. Spontaneous statements made without questioning are not subject to Miranda protections. The only conversation he had with officers before being read his rights was casual small talk. When he asked about his arrest, officers did not engage but simply told him he would be spoken to at the station. Legal analysis. Miranda v. Arizona applies only to custodial interrogation. Courts distinguish between interrogation and spontaneous remarks. Since Kohberger was not actively questioned, Miranda was not violated, as the arrest itself was lawful. There was no poisonous tree argument. Final court decision. The court denied all suppression motions, ruling law enforcement properly executed the search warrants. Exigent circumstances justified the rapid entry into Kohberger's parents' home. No Miranda violation occurred, as he was not interrogated before being read his rights. Implications. All evidence obtained from the arrest, searches, and statements remains admissible. Kohberger's efforts to weaken the prosecution's case by challenging evidence collection have failed. Conclusion. This ruling is a major setback for Kohberger's defense. The court's findings validate the police investigation and ensure that key evidence, including DNA, vehicle data, and electronic records, can be used in trial.
Yeah, Kohberger's screwed, you guys. And he's screwed because he's the killer. Okay, you understand that? It's not like it's, I mean, this is all real stuff, but his lawyers are trying to figure out a way to, you know, use some random, you know, tiny little issue or something. They're trying to make issues out of everything, and they're just not, it's not going to happen. Okay? Hey, thanks, Kami. And yes, you too, you guys. We're still 10 short of the nightly regular small end of the goal, but if we get 60 more, that's when I'll donate the 5 memberships. So if you're, you know. And by the way, the 60 can be made up of membership gifting too. So if you guys gift 12 memberships out there amongst you, then that'll get us there also. All right. Let's see. Let me try to find this point. 104. There it is, right there. All right. Let's see. There are 2 infirmities in defendant's argument. However, first, he entirely ignores the destruction of evidence exigency. which is what law enforcement relied upon greatly in dispensing with the knock and announce requirement here. The evidence demonstrates that while preparing to execute the warrants, law enforcement identified the defendant in the early morning hours as he turned on a light in the kitchen and then proceeded into the garage where his vehicle was believed to be parked. Law enforcement was aware that the defendant was suspected of having driven that vehicle during the commission of the homicides and knew it could contain evidence. Law enforcement then saw vehicle lights flash in the garage, as if a vehicle was being unlocked or locked. Immediately afterwards, they saw the defendant again in the kitchen wearing rubber gloves and handling a plastic baggie. Further, it was 1:09 a.m. in the morning, a time when most people would not be removing items from their car with rubber gloves. Jesus, you guys. This is all like new stuff here. It's sweet. I mean, we've heard this, but now we're getting a better description of it. These observations gave rise to the reasonable belief that perhaps, aware of law enforcement's surveillance, the defendant was destroying or secreting evidence of the crimes. Second, compounding the concern of the potential destruction of evidence, there was an equally compelling concern that a knock and announce could pose a serious danger to law enforcement. Law enforcement had reviewed the investigation report and probable cause statement provided by Idaho detectives. The executing officers knew defendant, based on compelling evidence, was believed to have orchestrated an unprovoked and exceptionally brutal quadruple homicide with a knife. They had information he was in possession of a Glock handgun. They knew he was in the residence, awake, potentially aware of law enforcement's presence and potentially destroying evidence, or perhaps retrieving his gun or a weapon from the vehicle. His vehicle was in the garage nearby, thus giving him a means of quick escape. While prior to allegedly killing 4 people, defendant may not have had an extensive criminal history or general reputation for violence, as did the defendant in Kitchener, it does not mean law enforcement's safety concerns were unreasonable given what they knew. When these circumstances are collectively considered, the court finds law enforcement was well justified in making an abbreviated announcement and forced entry. They probably just said, law enforcement, and broke in. Thus, suppression is not warranted. That's amazing, right? So we got new information there. All right, now I guess I'm gonna have to dance another jig again, you guys. We gotta get to the goals. Now here we go. This is the genetic genealogy portion. This is one I'm particularly interested in. Let's see what it says in this one. There's nothing.
Detailed summary of the court order on Brian Kohberger's motion to suppress genetic information. This court order from the district.
Why do you always do that, Cindy? Bethany Funk has nothing to do with any of this stuff, nor was she mentioned or talked about in any of the hearings that we just listened to. It has nothing to do with it. Like you get stuck. I feel like you watch some of those nut jobs out there.
District Court of the 4th Judicial District of Idaho addresses Brian Kohberger's motion to suppress genetic evidence gathered during the investigation. The court denied the motion, ruling that the collection and analysis of...
What are you talking about, Lindsay? Or Stephania? Gray looks at the cell phones and so on. Who? What? I don't get it.
DNA evidence were constitutional and did not violate Kohberger's rights. Case background. Charges. Kohberger is accused of 1 count of burglary and...
Did it stop? Oh, it looks like it. Let me see. Let me just go back to the beginning here and do summarize in great detail this PDF file.
Sure.
Thanks.
Please upload the PDF file, and I'll summarize it in detail for you.
Here, I'll get a different name in here. How about Oliver? Let's try that guy.
The document is a court order from the District Court of the 4th Judicial District of Idaho regarding the defendant's motion to suppress genetic information in the case of State of Idaho versus Brian C. Kohberger, case number CR0124 to 31,665. Below is a detailed summary of the order. 1. The defendant, Brian C. Kohberger, is charged with 1 count of burglary and 4 counts of first-degree murder. The incident occurred on November 13, 2022, when Kohberger allegedly entered a residence at 1122 King Road, Moscow, Idaho, and fatally stabbed 4 victims, Madison Mogan, Kaylee Gonkovs, Ethan Chapin, and Zana Kernodal. A knife sheath was left at the crime scene, and forensic testing identified male DNA from it. Law enforcement used forensic investigative genetic genealogy (IG) to identify Kohberger as a suspect. A trash pull from Kohberger's family residence was conducted to obtain additional DNA evidence, which matched the DNA found on the knife sheath. Kohberger was arrested based on this evidence. 2. Kohberger filed a motion to suppress the genetic information, arguing law enforcement violated his constitutional rights by conducting IgG testing without a warrant. The warrantless trash pull violated his expectation of privacy. All evidence obtained from these searches should be excluded under the fruit of the poisonous tree doctrine. The state argued that law enforcement acted lawfully and that no constitutional violations occurred. 3. The trial court has the authority to assess credibility, weigh evidence, and resolve factual disputes. A motion to suppress evidence involves both legal and factual determinations. A court's factual findings will not be overturned unless they are clearly erroneous. 4. On November 13, 2022, police discovered the 4 victims with stab wounds inside the residence. A Ka-Bar knife sheath was found on a bed next to the bodies of Madison Mogan and Kaylee Gonkovs. DNA was extracted from the button of the sheath and was determined to belong to a single male individual. The DNA profile was uploaded to the CODIS database, but no matches were found. Law enforcement pursued forensic genetic genealogy (IG) to identify possible familial matches. Othram Labs developed a single nucleotide polymorphism SNP profile and uploaded it to Family Treatna and GEDmatch Pro, which allow law enforcement searches. A list of potential relatives was generated, leading investigators to identify Kohberger as a suspect. The FBI later expanded the IgG search, including GEDmatch and MyHeritage, which purportedly disallowed law enforcement searches. A trash pull at Kohberger's family home in Monroe County, Pennsylvania was conducted without a warrant. DNA obtained from the trash matched the knife sheath DNA, identifying Kohberger as the likely contributor. Kohberger was arrested and law enforcement obtained a buccal swab from him, confirming the DNA match with a probability of 5.37 octillion times. 5. A. Kohberger claimed he had a reasonable expectation of privacy in his DNA, and that IgG testing should require a warrant. The state countered that the
Thanks, KME. Man, not sure why it's so hard tonight, but appreciate your support there. We got to that low-end goal. Now, if we get 50 more, we give away the 5 memberships. All right.
DNA was abandoned, and law enforcement had lawful possession of the evidence. The court ruled against Kohberger, finding he abandoned any privacy interest in the DNA on the knife sheath. The testing was for identification purposes only, which does not violate privacy rights. The testing of DNA for identity is no different than fingerprinting. Courts have consistently ruled that DNA left at a crime scene can be analyzed without a warrant. B. Kohberger argued that he had a privacy interest in the trash at his parents' home, citing local waste management ordinances and the fact that the home was in a gated community. The state argued that under California v. Greenwood 1988, once trash is left for collection, privacy rights are forfeited. The court ruled against Kohberger, finding there is no reasonable expectation of privacy in trash left for collection. The Monroe County Waste Ordinance does not create a constitutional privacy right. DNA in the trash was legally obtained and tested. C was the genetic genealogy. Kohberger argued that the FBI's use of GEDmatch and MyHeritage violated his privacy rights in the database's own terms of service. The court rejected this argument, ruling Kohberger had no reasonable expectation of privacy in his relatives' DNA. His relatives voluntarily uploaded their DNA to public databases. Even if the FBI violated the database's terms of service, this does not constitute a Fourth Amendment violation. 6. Final decision. The court denied Kohberger's motion to suppress...
You know, it's weird. It's almost like we were just watching my show. I mean, we said all this stuff. Every bit of it.
The DNA evidence. The court found that the IGG process was lawful. The trash pull did not violate the Fourth Amendment. Law enforcement had sufficient probable cause for subsequent DNA testing and arrest. 7. DNA left at a crime scene is not protected under the Fourth Amendment. IGG analysis for identification is lawful, as it does not reveal private medical or genetic information. A person has no privacy interest in DNA voluntarily shared by relatives in genealogy databases. Trash left for collection is public property and can be lawfully searched by law enforcement. Conclusion. The court ruled that none of the DNA-related searches violated Kohberger's Fourth Amendment rights. As a result, all DNA evidence, including the IGG search, trash pull, and subsequent buccal swab, remains admissible in the case against him. Would you like a further breakdown of any section?
Let's see. What part? Finding... Yeah, I don't think so. That was pretty damn good breakdown right there, wasn't it? I mean, that was just like, really easy to understand. That's it. I mean, Kohberger is, Ann Taylor tried, but all this stuff's coming in now, and I think this is where they start having the plea talks, because he has like no shot here, And the reason Kohberger is in a lot of trouble is because he's the killer. I mean, if you just use reasonable, thinking ability, you'll see it. There's one more. There's a state rebuttal, but I guess it's not really. It says, based upon the state's motion to seal exhibits to state's rebuttal to defendant's supplemental response to requests for discovery regarding expert witnesses filed herein and no objection from the defense, the court does hereby confirm and order that all exhibits attached to state's rebuttal to defendant's supplemental response to requests for discovery regarding expert witnesses are exempt from disclosure and sealed. So there you go. Yeah. So I hope this case is, we can watch it, Yeah, I mean, there's Alfred Plea. Alfred Plea is a joke, It's like, nobody in the world, if they were actually innocent, would do an Alfred plea. That's just like this isn't a case that an Alfred plea would be accepted. Okay, they try those in cases where the prosecution isn't very certain about the outcome as well, but the defendant isn't willing to risk it, so they'll do an Alfred plea and. Basically, they just admit that the law enforcement has enough evidence to convict them, but they don't admit to actually doing the crime. That's what that means. That's why I just explained what an Alfred plea is. An Alfred plea is you plead. You don't really plead guilty. You just sort of admit that. The state has enough evidence to convict you, but you are still maintaining like your innocence, but you get sent to prison. I mean, I guess I can just read it, what it says. I think I'm pretty close. Let's see. Alfred plea is guilty plea where a defendant maintains their innocence. It's used in criminal. So I guess you plead guilty. But you maintain your innocence. It's used in criminal court when a defendant accepts a sentence but doesn't admit guilt. There you go. That's basically what I said. All right, well, there you go. Well, I think that's all the summaries there, you guys. Anybody have any questions? I mean, it was an absolute rout. Ann Taylor's performance, I hadn't really watched her a tremendous amount. Like, I'd seen her a couple times prior. Everybody talks about how great she is. If you listen to all the pro-burgers, oh, she's the greatest attorney in the world. I thought she was terrible. You know, just as a regular person listening to her arguments and just almost childishness of the arguments. Like, but it's not okay though. I mean, you know, just asking him to make like constitutional decisions and stuff. She was terrible, you guys. Like absolutely god awful, and it wasn't even close. I bet there wasn't even a moment of thought by the judge like, boy, she made some good points there. I mean, it was just an absolute blowout. She's terrible, at least in those hearings. And I don't know what these people are talking about. They're just so pumped about Ann Taylor, like she's fantastic. She's awesome. I think she is bad, you know, at least in those hearings. So is there any chance to get the extra 50 in here tonight, you guys, so I can give away those 5 memberships? If not, I get it. You know, every night can't be a good night. Last night was a decent one in here, but it made up for the night before, which was one of the worst nights in the history of the show. Although it was only an hour long, I could just tell where we were going. I thought she was terrible too. Yeah, you could see it. Yeah, I think you're right. Like she knew she just wasn't very good, and I think she's kind of just done. Like, I think Ann Taylor absolutely knows that Brian Kohberger killed those 4 students. He knows it. Let's see. Lynn sent me something. Let's see if maybe we can play it on the side. It's apparently some interview with Steve on Brian.
I look a little tired in terms of in the case and heeding the evidence. You can look through my tweets and stories. You can read. I got a statement from the Gonzalez family. They say, "Praise the Lord. All the motions to suppress and Frank's motion have been denied. It's always a double-edged sword waiting. You want the right decisions to be made, but you also want them to be made quickly. We are thankful to the court for a timely decision and appreciate the work the prosecution has put in thus far. In the big picture of life, justice is just moments away. Thanks again for all of your support and love for our family." So the Gonzalez family, that's...
there you go. I mean, we could find that online. Yeah. Hey, thanks. Sandy Shirley gifted a membership. Now, if we get 9 more gifted memberships, I'll gift 5, and then we'll have a total of, what would we be? I guess we'd be at 22 new members. That'd be pretty sweet. So we need 9 more, and then I do 5. Let's go, freaks, she said. Let's see. My fingers shook all over my keyboard. So isn't this amazing, though, you guys? I mean, so now, what are the hearings about now? I mean, this just wipes out every single, like, conceivable angle that they had, that they tried to... I think this just sort of clears the deck for the trial now. It's like, there's nothing. Now, you could try to get something here and there removed or whatever, but I think it's... get on with what, Vicky? What are you talking about? Get on with the trial? Yeah, it seems like it, but, I mean, the trial isn't supposed to happen until August. I guess they were trying to get the firing squad back in there in Idaho, or maybe they did put it back in. Witnesses and... Yeah, I mean, I think they are going to stream the trial. They're just not going to show the pictures of the crime scene, etc. Don't you guys think? I mean, I think they're going to use the same the same camera setup and everything. So, but it's sort of a double-edged sword. Do I go to trial and let's see. So I guess we're not. You guys don't want to do the 9 extra memberships, so I can give away the 5. Man, this has been like pulling teeth tonight. It's wild. Anyways, Brian Kohberger got smoked. Okay, and for all those pro burgers out there, it's just not fair. Well, blame your idiot Ann Taylor. Judge might have ruled differently on some of these things. Erroneously, of course, but this judge here is a great judge. He's the kind of judge that I would think you'd want regardless of what side you're on, because he uses facts, and if you're guilty, you're going to go down. Okay, that's just what it is. The thing and this other thing, it's like she can't speak English. I expect Kohberger to represent himself soon. I don't know. Not sure what he's going to do. Yeah, but I'd want to go to see the crime scene photographs, like the way things were laid out and what actually happened, because they're not going to show those on TV, I can tell you that. So if you want to see, because seeing the crime scene is a valuable piece of information when you're covering cases. So there's a lot of stuff I wouldn't be able to see. I want to see like the walkthrough video they probably have in the building, like they usually have those body camera things. Maybe if I type it in, you guys will get moving here. We've got 328 people watching. If you get the like button, that'd be great too. We always got the rude people who show up and don't hit it. They just go, I'm just going to... So go ahead and hit that like button, hit that like button, hit that like button, 10, 20, 25, 30, hit that like button, 40. It's the easiest damn thing to do in the world. You just hit the like button, use your nose, use your toes, whatever blows, hit that like button. It's so damn simple, it's almost unbelievable. Yeah. Yep, use your nose, use your toes, whatever blows. But, yeah. Man, you guys, I don't really get it. One night it's good, the next night not. There's no reason for it. Thank you, Stephanie Stringer. Read the part where it says what Dylan Mortensen's... We already did that, Stephanie. Did you miss it? We went over all that. Now, they didn't say he vacuumed. They said it looked like he was carrying something that looked like a vacuum. You must not have been here when we went over that section. Yeah. Yeah, hit the like button. All right. Well, we got the 276. Let's try to get to 300. All right, everybody. Let's hit that like button. Hit that like button. 10, 20, 25, 30. Use your nose, use your toes, whatever blows. Hit that like button. There you go. It's the easiest thing in the world. Just hit the like button. So damn simple. It's almost unbelievable. Well, we got 0 on that one. It says 276. The other people are just rude, so... Yeah, we went over the whole vacuum thing earlier. Right. You must have been watching another channel that talked about it, and then you just jumped over here and assumed we hadn't. Let's see. I think the knife wrapped in cloth. Yeah, I don't think it would look like a vacuum cleaner. Right, I don't think it would look like a vacuum cleaner, though. Do you? Well, we've been on it for 2 hours and 34 minutes. It'd be nice to get to that number to give away those memberships. It's up to you guys. Did you mention something last night about one of the girls in the house seeing someone? Well, somebody claims, there's rumors out there that claim that Bethany Funk saw somebody getting dressed naked. Okay. That's just a rumor. Absolutely 0. I think that would be in the documents somewhere. Like, we would have heard about that at this point. But the defense didn't make any arguments about Bethany Funk, so we might not hear about it even if it's true. So even if it's true, they know that, oh wow, that kind of sounds like Kohberger actually mitigating the blood spatter. You know, so they don't want to bring that up, and the prosecution won't bring it up because they haven't been doing that. They haven't released any information that shouldn't have been put out there. But anyways, you guys, I think I'm going to get going here. Appreciate you guys being here, but maybe I'll got to go work on a video again. So thank you to Timothy Cecil, Wonder Woman, Alley Cake, Amber Maiden, Mama 457 Rose, what do we got? Kim Worth, a new member, Vicky White, Alley Cake, Moofies, Mama 457 Rose, Amber Maiden, Tumbleweed, Cheryl Moran. I'll just do this part now, and then maybe if you guys have questions or something, but it's me, Calamity, Kim Worth, Mama 457 Rose, Alley Cake, Susie Clue, Heather, Kami, Joel Burnt, Amy Lemoyne, Richard Watts, Alley Cake, Moofies, It's Me, Calamity, Heather, Detective Wisdom. So we had a lot of different people, but it used to be like it's like the average amount is smaller, I guess. Cheryl Moran, GSUPM, Persis 57, Kim Worth, Patricia Selby, Sandy Shirley, Cheryl Moran, Gifted 5, then Mark, then K-Me, then Case Cracked, K-Me, then Sandy Shirley Gifted membership, then Stephanie Stringer. Yeah, that was pretty good. Pretty good. Just I hate the struggle, always continuing to say, hey, everybody can help support the channel. It should just be something you do, you know, because I do these shows every single day, and there is no ad revenue on them. Thank you so much for another great show in the library of great information. I think that worked pretty good having the Chat GPT summarize it, didn't you? And then you go back and deep dive into the interesting points. I thought it was way better that way, because then we went back and looked at the points that were more interesting, right? And so what we've learned is that there is a camera that filmed that absolutely identified the White Elantra missing a front license plate. So there is a surveillance camera that did that, and Taylor seemed to admit that that camera exists. And in the hearing, the timing matches perfectly. Now that video on Linda Lane that I showed you guys, it shows the street kind of far away over there, and it's missing the 330 to 405 sucks, because that camera right there would allow you to complete the looping, timing up with the camera, the other Linda Lane camera, when it's going back behind there, and then especially if you had the 1112 King Road camera, where you could tie them all together and it would absolutely be obvious that we're all looking at the same vehicle each time. But for whatever reason, those people that put out the Linda Lane footage intentionally hid that portion, because they probably knew it made Kohberger look bad, because that would be the only reason you would do that. Well, I showed you how to do it on the screen. I have to pay for it. But anyways, all right. There you go. And thanks to also the people on Steph and Susie Clue and Lisa Valenzuela, and then also Miss Angels on PayPal. Thank you. I don't know, Deborah. I just try on a nightly basis to try to raise the funds for the channel, and I don't like having to do it. I've explained it to you guys a lot of times, and it seems like if I just say it once, you know, maybe that should be enough for people to go, okay, you know. But unfortunately, it seems like it's not like that. Didn't used to be. I did see Vinny play a clip from one of your lives today on his show. Oh yeah, what was it? Because was that the one where he was on here saying, "Hey, good show"? That one? Was it was it well received? What did it say, Kami? What did it say? Yeah, he was talking about the loops. Right. Yeah, I've gone over that 100 times. I think the loop's different now, though. It's not... I used to think it was the car came in, left, came back around, and we go like this. But now it's like the vehicle comes in and goes this way, comes in and then leaves the same way, and then comes back around this way, comes in, and then when it leaves, it goes that way again, and then comes back later and does come back in this way, and then goes back in, and then it sort of, that's the final pass coming in. So it's different than what I thought it was. Anybody have any questions? I don't want to make a sound clip, Deborah. That'd be weird, you know. Although maybe it would be better, because then it wouldn't be me sounding frustrated some nights, because I definitely get frustrated. Huh? Let's see. So now people are saying that the vacuum part might be... he was carrying a vacuum, and it's you know, when you're trying to like edge vacuum, that little pointy part. Oh, that's what it was. No. Nobody's going to say it looked like a vacuum. Nobody would say that. If you said it looked like a vacuum, it's going to be some big object. I don't think anybody would say, oh, it looks like a vacuum. You know. I'll show you the picture that people are talking about. This thing right here, look. See that? Oh, look, it's a vacuum. I don't know, man. I think that'd be like 1 in a billion that somebody would refer to that as a vacuum. I don't see it. I don't see that at all. That'd be strange. Well, thanks, Mama 457 Rose. I was wondering if he went anywhere near the observatory and if that's where he came up with... No. He just came up with stargazing because he said that he likes to stargaze, and then he drove over here to Wawawe Park. Unfortunately for him is the phone pinging over here at 448 near Blaine makes it impossible for him to go on to Wawawe Park and then have his phone ping in Pullman, Washington at 5:30. In fact, they actually have his vehicle coming back at 5:25 driving this direction. So it's here at like 2:50 in the morning. It's over here at 3:26. Then it's down after the murders. It's down in this area at 4:48. And then I actually timed this drive. It's absolutely perfect. And then at 5:25, after driving up here, it makes its way to here. This part here is a crazy little turn that you take. Boom. See, and I think Kohberger would do stuff like that. Like that morning, when they say his car went this direction, I think he probably came up like this, drove down this highway, maybe turned here or whatever. We don't really know. I mean, there's a whole bunch of different roads that intersect. You could take this road and see how it kind of intersects over here, and then maybe you can drive back over into this area and then end up over here at a lot of different ways. It doesn't help the defense when they say, 7 minutes isn't... Don't underestimate how important 7 minutes is. Hey, I don't mind if he goes the other direction. In fact, I've always wondered where he was. If he leaves over here at 2:40 something, then we first see him over here at 3:26. What was he doing for like 30 minutes? Because it doesn't take that long to drive there. But hey, you just admitted that he went the other way. He went over here and he starts, now here's where some of the time is killed. He's way over here. Then eventually he cuts across somehow, and then he makes his way up here. So it actually helped my theory, because I didn't know. I was kind of wondering where he was for such a long period of time. If he had driven straight to Moscow, he would have been there at like 3:10. at the latest, maybe 3:05. Instead, he was there. First shows up on Indian Hills Drive at 3:26. Anyways, tonight I do want to give, let's see, special thanks. I don't seem to be able to scroll around for some reason. Let's see. Oh, there it goes. Cheryl Moran, multiple super chats and support. So thank you. Appreciate that. Very kind. Yeah, good for you, Caleb. Wow, what an interesting comment. Hey, Gray, I think BK is a tool, and he knows that. Yeah, he's a quadruple killer, you know. Let's see. I think he's an incel. That's what I think. All right, everybody. Thank you all for being here tonight. We'll see you guys tomorrow. And as I always say, until next time, be safe out there. Yeah, I've been doing this true crime thing for quite a while now. And during this whole time, I have not seen one person that is a crime dissector, thug rejector. I'm a certified human lie detector. Gonna get ya on a stretcher if you try and play me like an old projector. Crime sector is my nectar. Professor Gray is gonna give another lecture. Crime collector, freak connector, and I'm always gonna be a pup protector. Fool deflector, interceptor, and I'm meaner than a spectre with a vector on his pector. With all respect, y'all, just remember I've a temple fucking check ya. I have no agenda, I'm no pretender, and I'll serve it to you straight without the blender. And in the end, I'm gonna send ya on a mission to reveal the true offender. Yeah, so I'll just get right back to work. All right, everybody, talk to you later. All right, check it out, you guys. We're just gonna make, hey, type something in, Kimmy. Type something in. Say something. Let's see. Good night, be safe. Yeah, well, the bunny is a trigger bunny. Trigger bunny, honey. I'm just still sitting here reading the comments. I'm waiting for K-Me to type something in. She probably already took off. Well, I made made K-Me a moderator after all these years. So I thought maybe if she typed something in, you could see it was blue. But she must have taken off. Anyways. All right, everybody. See you guys later. Have a good one.